Okay, Mr. Pacita,
Yes, good morning or good afternoon. No, it still is morning. Good morning, Judge.
good morning. Please turn your camera on, counsel.
Oh,
This one's Alyssa's fault, and Brecken put it together for me.
Good morning. Which matter are you here on?
I'm sorry, Judge, and I was just trying to rename myself. I'm with Neighborhood Defender Service. I don't know whether you have heard, but there's been a work stoppage. I'm a supervisor. So I guess I'm here on behalf of Miss Ridgewood, on the last name is Salim.
Yes, that's in person, counsel.
Okay.
Yes, that's in person.
Oh. Judge, I'm afraid I'm here down at Frank Murphy, a little old school. I'm here at the Criminal Justice Center with several other matters.
Well, counsel, this matter is in person. This matter has been adjourned a number of times.
Ooh, Judge DeSanto is not happy, and I know why.
Judge, I get that, and I understand that you have appointed Miss Ridgewood as standby counsel.
No, counsel, that's not how that went. But we're not on the record right now, but I can address that in just a short bit. The court didn't appoint any attorney because the court doesn't appoint attorneys. The assigned counsel division of the Third Circuit Court appoints attorneys. So if is Mr. Mohammed here?
Yes, Your Honor.
Okay, then we'll go on the record on this matter here in just a moment.
Making him do standby?
There, thank you. Okay. Okay, let's go on the record. In the matter of the state of Michigan versus Mohammed Salem, 26586. An appearance for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Thank you.
Also, good afternoon, Your Honor. Maria Murad on behalf of the people.
Thank you. Ms. Murad, your P number, please.
80605.
Okay, and for the defense.
Mohammed Salem.
All right, and counsel?
Yes, Judge. My name is Mark Persida. I'm with Neighborhood Defender Service. My P number is 39242.
Okay, PROCIDA, correct?
That is correct.
Okay. All right. Today's the date scheduled in this matter for the adjourned preliminary examination and bond violation hearing. This matter was adjourned from last week. Well, I'm going to put forth the procedural history of this matter. Mr. Salem was in custody in the Wyandotte Police Department when his arraignment was held on May 8th. At that time, the court set the probable cause conference for May 21st. Set a bond of $30,000, 10%. No weapons. All weapons are to Wyandotte Police Department for safekeeping. GPS tethered through the Wayne County Jail. On May 21st, the probable cause conference was held. Time was waived on the record. At that point, it's important to note that Mr. Salem had a retained attorney, Matt Savage, P number 51264. On May 21st, defense requested an adjournment to review discovery. We adjourned the probable cause conference to June 11th. Bond and conditions are continued. On June 11th, then there was a bond violation in the interim. On June 9th, it was sent to Mr. Salem's attorney. On June 11th, there was an emergency motion for Mr. Savage to withdraw. That was consented to by Mr. Salem, as well as the prosecutor. Court granted motion. There was an order to follow. Defendant wanted to represent himself. On the bond violation, Mr. Salem entered a plea of not guilty. We scheduled it for hearing June 18th at 1:30 p.m. as well as the preliminary examination, June 18th at 1:30 p.m. Witness and exhibit list by June 15th. Bond and conditions are continued. June 18th, officers were not for the bond hearing. Made most sense. Everybody's was a collective by Mr. Mohammed, Mr. Salem in the court that it was sense to hold those together. So the court exam and the bond violation hearing to July 2nd at 1:30 p.m. July 2nd, the bond violation hearing was not held and neither was the exam. Defendant was now requesting an appointed attorney. And I believe Mr. Mohammed, on that date also agreed that Mr. Salem should have an appointed attorney. The court adjourned the exam and the bond violation to July 16th and set a probable cause conference on July 9th. That's all accurate so far, correct, Mr. Mohammed? Mr. Salem?
Correct, yeah.
Okay. On July 9th, Mr. Salem wasn't present when the case was called. Mr. Salem did, however, file motions at the window. And so the court set the motion hearing for the same date as the exam on July 16th, as well as the bond violation to remain for July 16th, so long as the witnesses were not available on another state day in July. Because we were running short on time based upon this court's scheduling order. Counsel, you're on the phone for this case?
Yeah, Judge, I received a vibration, so I just put my phone on silent.
Thank you. Then on July 16th, the court will note that it had an extremely long docket. This court didn't call the case until 5:37 p.m., noting that there were attorneys here, Mr. Salem was present, witnesses were present, all necessary parties were present. At 5:37 p.m., the court did ask the parties if there would be an opposition to adjourning it to another date, that being today's date at 11 a.m. Because, well, actually, the court didn't ask if there was opposition. The court suggested it because we had just had a jury trial that was scheduled for today's date cancel. So that then opened up the date, and this would have been the only matter on the docket that day. All the attorneys or all the witnesses indicated they were present. Mr. Mohammed indicated that he would have difficulty being present because he was assigned to the 28th District Court. The court stated it would reach out to his supervisor to let them know that it was not Mr. Mohammed's request to be on July 24th. However, this court was ordering it to be July 24th based upon the availability of all witnesses and Ms. Ridgway, who is the attorney appointed to represent Mr. Salem. And then we set it for a later time in the day so Mr. Mohammed could complete his 28th District Court case. I will acknowledge that this court did not reach out to the supervisor, as it did not end up having an opportunity to do so, given the nature of the docket this past week. So then also on July 16th, defendant was withdrawing his motions that he had previously filed. The prosecution also moved to dismiss counts 2 and 3 based upon the MSP report. Is that accurate recitation of the procedural history of this case?
Yes, Judge, everything the court has stated is accurate and correct. The only addition I would add is for all prior preliminary examinations, I had my witnesses here. They were present
No, they were not.
for the preliminary exam.
Oh, I'm sorry, preliminary exam.
For all preliminary
Yes.
exams, but
Whose phone just went off? Please make sure your phones are on silent.
just in regards to the preliminary exam, all witnesses were present at every single case. We were ready to proceed on that. There was, like the court indicated, that one bond violation hearing date where one of the officers was available via Zoom, but the court correctly said that this should be done in person. And we were all in agreement that we'll adjourn it to another day so that we can have the bond violation hearing first and then the preliminary exam.
Very
So
good, thank you.
everything the court has stated is correct.
Perfect, thank you. Mr. Salem, would you agree with that or no?
Yes, Your Honor.
Okay. All right, so I then received communication from Mr. Salem, well, not myself directly, the court did, from Mr. Salem, which was addressed to the 27th District Court, Ms. Ridgway, Mr. Mohammed, and our criminal clerk. So I'm going to read this letter into the record because I think it's important for this to be in the record. Letter to the court. Your Honor, I respectfully submit this letter to place on the record concerns regarding a telephone conversation that occurred prior to my scheduled court appearance. On or about today, I participated in a three-way telephone call with the appointed attorney's manager and the prosecutor's manager. During that conversation, I was asked to agree to adjourn tomorrow's hearing due to funding and appointment issues. I respectfully declined, explaining that this case has already been delayed far longer than necessary. Numerous witnesses have already taken significant time away from work because of my prior continuances. I have already filed my motion with this court, and I wish to have my motion heard and placed on the record as scheduled. During the conversation, I was encouraged to adjourn the matter because it was represented that having standby counsel would be in my best interest. I again respectfully declined and stated that I wished to proceed in propria persona and exercise my constitutional right to represent myself. During that same conversation, the prosecutor's manager stated, to the best of my recollection, I assure you she will not dismiss it. She also questioned where I obtained my legal knowledge and asked whether I had received my law degree from ChatGPT. I respectfully submit that these comments were unprofessional and unnecessarily discouraging toward a self-represented defendant. Every defendant has the constitutional right to prepare and present legal arguments, regardless of whether those arguments were drafted personally or with the assistance of legal research tools. More importantly, I am concerned by the statement, I assure you she will not dismiss it. I want to make absolutely clear that I am not alleging that this court communicated any decision to the prosecution, nor am I accused the court of any impropriety. I am simply placing on the record that this statement was made to me before my hearing. From the perspective of a self-represented litigant, this statement reasonably creates the appearance that the outcome of my motion had already been predetermined before I had the opportunity to present my arguments in open court. Whether or not that was the speaker's intent, such statements diminish a defendant's confidence in the fairness, impartiality, and integrity of the judicial process. I also advised both parties that I intended to appear in person at 8:30 a.m. as instructed. As further stated, I further stated that I wish to move forward with my hearing without additional delay. This matter is already extended far beyond what is reasonable, particularly considering that 2 felony charges were dismissed after laboratory testing established that the alleged cocaine was in fact prescribed ketamine. These circumstances have already caused substantial hardship, expense, and delay. I respectfully ask that my previously filed motion be heard as scheduled. Constitutional legal concerns. So I'm not going to read that portion because there was a motion filed. I'm going to address that in just a moment. So I'm going to skip to the next portion of the communication. I further believe these circumstances raise concerns regarding the spirit and purpose of the Michigan Rules of Professional Conduct, including but not limited to MRPC 3.8, special responsibilities of a prosecutor, requiring prosecutors to seek justice and protect the fairness and integrity of criminal proceedings. MRPC 3.5, maintaining the impartiality and decorum of the tribunal and avoiding conduct that undermines confidence in the judicial process. MRPC 4.4a, prohibiting the use of means that have no substantial purpose other than to embarrass, delay, or burden another person. MRPC 8.4a through 9, providing that it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, or engage in conduct that is prejudicial to the administration of justice. I am not asserting that these rules have been violated as a matter of law, putting emphasis on not because it's bolded. Rather, I respectfully submit that the comments made to me before the hearing raised concerns regarding these professional obligations and the appearance of fairness in these proceedings. The United States Supreme Court has long recognized that due process requires a fair trial and a fair tribunal. Henry Murchison, 349 U.S. 133, 136, 1955. Likewise, justice must satisfy not only actual fairness, but also the appearance of fairness to maintain public confidence in the judicial system. As a self-represented defendant, I respectfully request only what every litigant is entitled to receive, an impartial hearing in which my motions are considered solely upon the law and the facts presented in open court. For these reasons, I respectfully request that this letter be made part of the record, that my motion be heard as scheduled, and that the court take these concerns into consideration to ensure these proceedings remain fair, impartial, and consistent with the constitutional protections afforded to every defendant. Respectfully submitted, Mohanad Salem, defendant in pro per, July 23rd, 2026. So that is now read into the record. Now, I'm going to address a couple things here. Number one, the court has been provided notice that the Neighborhood Defender Services Division, who was appointed by the Circuit Court of the Assigned Services Division, Assigned Counsel Division of the Third Circuit Court, was assigned to represent Mr. Salem. This court received an email about 10 o'clock last night, or maybe it was before court opened this morning. At some point, received an email requesting parties appear via Zoom at 8:30 a.m. Well, this court had previously adjourned this to 11:30 a.m. First of all, it was never set at 8:30 a.m. It was originally last week, this court stated 9 a.m. Mr. Mohammed requested 11 a.m. so he could finish his docket at the 28th District Court. Once Mr. Mohammed noticed that he had a preliminary examination, he requested this matter be moved to noon. This court defined that and set it for 11:30 a.m. So it was never scheduled at 8:30 a.m. It was 11:30 a.m. and Mr. Salem was involved in the communications regarding that new time. Would that be accurate, Mr. Salem?
Yes,
Okay. And so would that be accurate, Mr. Mohammed?
Yes, and thank you, Judge, for that.
Yes. Now, then, much to my surprise, when I was on Zoom holding some in custody arraignments today, I noticed Mr. Persida on Zoom. This court informed Mr. Persida off the record that this matter was scheduled for in person. And Mr. Persida indicated then that he was down at the Criminal Justice Center and that he had a bunch of cases he had to handle down there. Would that be accurate, Mr. Persida?
That's accurate, Judge. We've been doing that all morning.
And so then Mr. Persida further stated that this court appointed the Neighborhood Defender Services to sit as standby counsel. That is not, this court did not appoint Neighborhood Defender Services. Courts don't appoint attorneys anymore. They're appointed attorneys by a division. Courts do not appoint the attorneys anymore per the MIDC statutes and additional statutes. So this court did not appoint Neighborhood Defender Services. The Assigned Counsel Division appointed Neighborhood Defender Services. And Ms. Ridgway did appear on Mr. Salem's behalf last week, and in fact, advocated on behalf of Mr. Salem as well. So, counsel, this is to be in person today, not on Zoom. It's not appropriate for an attorney to be on Zoom when his client and all witnesses and the prosecutor are here in person. And a matter cannot proceed accordingly.
Judge, a couple things, if I may. Both my supervisor and myself were under the impression that the court was asking us to remain on the case as standby counsel. Whether the court made a determination of that or not, obviously I wasn't there. The second issue that arises, if I can address that issue as well,
Which issue?
Of whether we are standby, or the court requested us to be standby. I don't know, Judge. That's what I was operating under, the assumption that the court requested us to remain on the case, that the defendant does not no longer wants our representation, if he ever did.
Well, counsel, I don't have a motion. I don't have a written motion. There was nothing that was submitted to the court that your office would, or Ms. Ridgway was requesting to withdraw. And there was a request for an appointed attorney for felony matters. That request was sent down to Third Circuit Court to the Assigned Counsel Division, whereby Neighborhood Defender Services was appointed to represent Mr. Salem. And Ms. Ridgway was here on his behalf last week.
Your Honor, if I may, yesterday's telephone conversation was as a result of a communication I had with APA Mohammed, in which he indicated that there is a strike at NDS and that instead of Ms. Ridgway, we're having Ms. Jackie appear. I reached out personally as well, first of all, my name is Maria Murad. I'm the lead prosecutor for Out County.
Okay, well, hold on, counsel. We're not to that point yet. We're not to that point.
The only issue I wanted to address is that Mr. Mohanad Salim indicated yesterday to Ms. Christine Longstreet, the supervisor, he does not want the representation. Even in his letter to you, he said he wants to be pro se and doesn't
Okay,
want.
that's great. That is great. That is not procedurally how things occur. And everybody knows, as practicing attorneys, that that is not how that occurs. There is a process. There are the court rules that exist for a reason. So simply a defendant telling somebody that they no longer wish for an attorney to represent them does not negate that attorney's responsibility from appearing in court. That is not how the process works.
It is my understanding that Christine said she could make it, and I can send her a message and tell her to come because she said,
Christine Longstreet. Who is Miss Longstreet to this case?
She is the managing attorney of NDS.
To be present, why is she not present 55 minutes after this was scheduled?
That I can't answer, Judge. All I know is I was asked to Zoom in today. I will confirm that Attorney Ridgewood, she is on strike along with most of NDS. And I can say that obviously she's not available.
so Judge, if I can clarify, yesterday's phone call was simply to let the defendant know that Miss Longstreet will appear instead of Miss Ridgway. He refused to listen, kept indicating he's feeding his daughter and has no time to. And then she also indicated to him they don't do standby and they have to get that clarification from the court. If they are standby, their contract doesn't allow for that unless they are fully appointed.
Excuse me, if that was the case, then there should have been an attorney here to address that issue and to clarify from Third Circuit Court if that wasn't, or from the assigned counsel division, if that was in fact the purpose of the assignment, then to make sure there was another attorney assigned to represent Mr. Salem. That's how the process works. The attorney should not just be sitting and waiting until 7 hours before the hearing to address this matter. Even
Correct.
12 or 15 hours before the hearing. Ms.
And I
Ridgway
agree.
was here. Ms. Ridgway was here last week. So Mr. Presida, there could have been a conversation with Ms. Ridgway last week, and then there could have been a motion filed or to clarify or to withdraw, what have you. There's not. So now here we are on what has now been let's see here. 6 adjournments. There have been 6 adjournments. So now here we are. And now this is coming up again.
So Judge, yesterday, Mr. Mohanad indicated to both of us, without agreeing to listen to anything we were saying, that we were telling him the judge makes the ultimate decision whether she will allow you to proceed alone or with an appointed attorney. He kept indicating, no, I make that decision. I'm going to appear alone and I'm going to be there at 8:30 a.m. I reminded him it's at 11:30. He was extremely hostile. And then Christine indicated, Ms. Longstreet said, well, the matter is set for 11:30. We will be on standby to hear whether the judge decides we have to, she's going to allow him to proceed or not. He also kept interjecting and saying, this matter is going to be dismissed tomorrow, which was my response to him. I assure you it will not, because I know my witnesses are there, Judge. So,
Okay, but hold on a moment. I'm just going to speak to that at all. Nobody speaks for this court. Not defendant, not defense attorney, not prosecutor, not witnesses. Nobody speaks for this court except for the court. There's no response to that. I'm not interested in anybody's response. Nobody
You will respect my authority.
speaks as to what this court's going to do other than the court. You may all have your assumptions,
I mean, she's right, but it's funny.
premonitions, whatever it may be about what you think this court may do, but this court speaks for itself. So nobody should be assuring anything to anybody about that. Further, whether, as I stated previously, whether Mr. Salem stated it was his intention or not, a defense attorney should have been here with Mr. Salem as ordered. Not just on standby. That's not how that goes.
Judge, and I can appreciate that. We did not know whether or not the strike would actually be taking place until after 6 o'clock yesterday. The supervisors are trying to cover all the matters in all the district courts as well as matters in circuit court. We've got a limited number of supervisors. It wasn't my understanding, Judge, that we needed to be there in person.
I'm not sure how you didn't get that understanding, counsel, when it's a preliminary examination and bond violation hearing. Further, if you thought that there is a possibility that you would not be able to cover all of the cases, then perhaps there should have been a communication to assigned counsel division to have them reappoint somebody different. And give them notice. I will state for the record that Ms. Ridgway did yesterday on another matter that she was here on indicate that the Neighborhood Defender Services was likely going to be on strike, and that she was assuring that she'd been assured that her supervisors one of her supervisors would be appearing in her place. So when I did see her face in the morning, that would be why. Is that accurate, Mr. Mohammed? Were you in here when she made that statement?
Yes, Your Honor.
Okay. So
Judge-
that's where we stand.
Longstreet indicated she could be on her way right now to hold this exam.
And so how long would that be?
I just asked her what your ETA is. She's typing.
While we're waiting for that response, the court will note that it is in receipt of Mr. Salem's motion that he filed. It was a new motion that was filed late July 22nd. That is not timely filed, so this motion's not being heard. It was not timely filed. There are court rules that allow for when a motion should be filed, and if there is a request to waive the time that's put forth in the Michigan court rules, then that needed to be requested by the defendant of the court, and that was not done. Mr. Mohammed, in addition to that, did you receive a copy of the motion?
Yes, Your Honor, and Your Honor, I would have objected based on exactly what Your Honor had mentioned pursuant to MCR 2.119C as well as relevant Michigan Court Rule 6.001D. I don't believe that it was timely. It's 2 days prior to today's preliminary exam. Additionally, I did just want to note for the record that the defendant did
I don't want to bore people with this, but I think it's absolutely insane. Absolutely insane. If you have an appearance entered on a file, you have an ethical obligation. We're not striking like we're on the auto production line here. You have a professional obligation. I don't know the inside story of this, and I don't know exactly what that entails. But if they think that they can just throw a hissy fit and not show up to their appearances, they should lose their licenses. Simple as that. You just violated your ethics.
previously submit a motion with the court. However, on his own initiative, it was withdrawn.
Right, I stated that. That was last week. Yes,
Thank you.
you're welcome. Ms. Murad, did you hear anything back from Ms. Longstreet?
No, still waiting for her to type, Your Honor. I think she's trying to get in her vehicle to just see what the ETA would be.
Mr. Procida, do you know where Ms. Longstreet's currently located as far as what her, so we can project what time she should be here?
Best of my knowledge, Judge, I know she was down here at CJC,
Okay, so at most 30 minutes.
probably.
Okay,
And the prosecution has no problem with that. We're willing to wait. Judge, there was just one thing I wanted to place on the record and
just one moment, just one moment. Mr. Salem, any objection to waiting the 30 minutes?
As long as it's
Just stand up
exactly,
when you approach the
Sorry.
court.
as long as it's 30 minutes, I mean, this keeps getting delayed every time I call. And I also wanted to say for the record, when I spoke with the prosecutor yesterday, I stated that I filed a motion to dismiss. I never said that you were going to dismiss the case. I said I filed a motion to dismiss and I wanted that to be heard tomorrow. And then she stated, I assure you, she will not dismiss it. I just want to put that on the record that I did not say that you were going to dismiss the charge.
Okay, and I was very clear as to what everybody should, I was very clear as to what everybody should not presume or assure anybody as to what this court's going to do. Sir, I also state that it may not be exactly 12:03 that we begin, because sometimes matters take my attention elsewhere here within the court, as I'm the only judge. So I understand it's been delayed, sir, but I will state as well, July 9th, you failed to appear for your exam.
I was here July 9th.
You were not here at the time your exam was called, the time your case was called. You came, you dropped off your motions, and then you left. You were not here. You were not here when the case was called. I'm not saying you weren't here at some point, which is why I did not issue a warrant. Yes, Ms. Murad?
Judge, I just want to say, I don't appreciate the lies that he's making on the record.
Back and forth.
He said,
No, Ms. Murad, I'm not going back and forth with this. I made it very clear. Clearly, there is misunderstandings, misconceptions, miscommunication between both sides. I'm not doing a back and forth with it. I'm just shutting it down right now that nobody speaks as to what this court's going to do or not do. That's it.
that's
That issue's done.
what I was trying to tell Mr. Mohanad yesterday, that you make the call and what you say is what works.
Hey, counsel, I just said we're done with that issue. We're not moving forward on it. Mr. Mohammed, you had one other thing for the record.
Thank you, Judge. It was just in response to the defendant's motion or letter to the court. I just wanted to place as an officer of the court, Ms. Murad has displayed professionalism throughout the
No,
court.
no, no. What-
I mean-
Counsel, let me clarify. I'm not going to address issues within the letter other than assuring somebody what this court's going to do or not do, or making a presumption what this court's going to do. I'm not going to do that. Ms. Murad she's present. She can defend herself if she so chooses. And again, I'm not indicating that anybody acted in an unprofessional manner or violated any Michigan rules of professional conduct. I'm not alleging that at all. I simply read this in here. I was not a part to any of those conversations at all. So I want to make sure we're getting this matter heard today or otherwise disposed of one way or the other, whatever it is we're doing in a timely manner. Because this matter, as I've stated before, has been adjourned 6 times for various reasons.
So I would like to adjourn it until my motion is able to be heard because my standing attorney read the motion and okayed for me to submit it, gave me the emails for me to submit it at that time. And now I'm being told that that is not enough time. So
No, I don't see any money in this mess.
Sir, it's not. The Michigan Court Rules 2.119 has a
Absolutely not.
minimum of 7 days.
I respect that.
And that way it gives the opposing party an opportunity to respond.
I respect that 100%. So my standing lawyer is the one who suggested that.
Great. Well, your standing lawyer is going to be on the way.
She's on her way.
Have you heard back from her, Ms. Moran?
Yes, she's on her way. She said 24 minutes right now.
First. Well, consistent with my half-hour
Yeah.
approximation. All right, we're going to go off the record. We're going to have everybody step out in the lobby and we will resume this matter.
Absolutely. I've never seen this before. And I've been practicing for 30 years. I've never seen it. For just the reasons I said, I don't know the thing, so I don't want to comment too much because I don't really know what they're doing or how they're doing it. But if these are attorneys who literally said, I'm not showing up to my court appearances, as is my obligation under the law, because I want to make some more money and my feelers are hurt, get them out. Get rid of them if that is their position. We have no space for them in the profession. None.
shortly.
Thank you.
Thank you.
Thank you, Judge.
So that is back to, that's not signed, it just goes back to the probation. Okay. All right, so let's go on the record in the matter of the state of Michigan versus Mohammed Salem, 26586. An appearance for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Thank you.
Mohammed Salem.
Thank you.
Christine Longstreet from the Neighborhood Defender Service, 5299.
Okay, thank you very much. And so today's the date scheduled for the bond violation on this matter, as well as the preliminary examination on count 1, carrying concealed weapon. Counts 2 and
Yes, the supply and demand issue has been around since the beginning of time. What happens is everybody quits. They don't walk out on their current representations. They say, I'm done. However, I will, give 30 days notice or whatever and appear at all my appearances in the meantime. If everybody walks out of your office, then you have to pay more to attract people to get there. What you can't do is walk out on your obligations. I'm not saying they did because I don't know. But if that's what they did, they need to go.
3 were dismissed on July 16th of the last court date, after the Michigan State Police Lab report had been returned.
Your Honor, I'd like to address the court before we begin. You stated that the 7-day rule under MCR 2119 states that I have to have a 7-day window, but
Hold on 1 second,
yes.
please. Judge, I just met Mr. Salon. I've been in contact, Salim, actually. I've been in contact with Mr. Mohammed yesterday. And I have spoken to him, and I just want the record to be clear. Did the court allow my client or Mr. Salim to represent himself?
Well, here's,
Okay.
let's see, I went on June 11th, Mr. Salem's retained attorney had an emergency motion to withdraw. Prosecutor did not object, Mr. Salem did not object, and so the court granted the motion. Then Mr. Salem wanted to continue on representing himself. Then on June 18th, the parties were here. On June, but things were adjourned because we had people not available for the bond violation hearing. So we adjourned both matters to July 2nd. On July 2nd, the bond violation was not held, neither was the exam, because defendant was then requesting an appointed attorney. So we adjourned both to July 16th and set another probable cause conference for July 9th for the appointed attorney to attend. On July 16th, I will say on July 9th, there was an attorney here on behalf of Mr. Salem, I believe it was Ms. Ridgway, and Mr. Salem was not present when the case was called. He did, however, file motions earlier that day, and so the court did not issue a warrant for Mr. Salem for him not being present when the case was called. And we set the probable cause conference for July 16th. The bond violation date was still July 16th. So we were going to continue with bond violation. But then on July 16th, our day went much longer than expected, and we did not call this case until 5:37 p.m. And so given the number of witnesses that were present and how long it was expected to take, the court set it for today. And with that, on July 16th is when the people moved to dismiss counts 2 and 3 based upon the lab report that they had received from the Michigan State Police. So, and then while Mr. Salem and Ms. Ridgway were here on July 16th, Ms. Ridgway did in fact advocate on behalf of Mr. Salem.
Your Honor,
But that gives that new light.
that was very helpful, because in this moment, I believe that Mr. Salem wants to represent himself, which my understanding of it, so Judge, can I just give you a short history, and I know, so, first of all, our, Ms. Ridgway is out on strike today.
I understand that.
And so in preparation for coverage for all the cases today, I looked in our data system to see that there was a note that Mr. Salem Lee
It's okay.
was going to represent himself. So I'll pause, full stop, and that apparently was put in the system by Ms. Ridgway. And so it's the.
I'm sorry, when was that put in the system?
And I'm talking about our NDS system. Cause I need access to my.
Judge, while the defense counsel is doing that, I just want to place one thing on the record. It's a procedural history thing. In regards to the hearing where the defendant failed to appear, I believe that was a PCC, not a preliminary exam. And I also believe that at that time, no one appeared to come to defense. It was just.
No, no, I'm pretty sure Miss Ridgway was here. If I recall correctly, there was somebody that was here, but couldn't explain why he wasn't here. And you're correct, the probable cause conference was July 9th, but the bond violation hearing was scheduled. As well as the preliminary exam for the 16th.
Correct. It was following the preliminary exam. It was the PCC that he failed to appear at.
Correct.
Okay. So, Judge, in our coverage thread, I can read this for you and show it to you if you like.
I don't need to see it. If you can, you're about to tell me when, so Miss Ridgway stated Mr. Salem wanted to represent himself.
Well, Ms. Ridgway was out on strike, so if Ms. Pilkowitz, who is Ms. Ridgway's supervisor, asked who
Can you spell, I'm sorry, can you spell the name Pilkowitz, please, counsel?
Pilcowitz,
Okay,
asked who is going to wind us tomorrow. Martha has an 11:30 exam. We are standby counsel for pro se client.
I don't know, I don't know, counsel, where that all came from within your office.
Yes.
What I can tell you is that Mr. Salem requested an attorney be appointed. Because we were prepared to proceed with the bond violation and the exam on July 2nd. And at that point, Mr. Salem wanted to have an attorney represent him, correct?
Standby counsel,
Sir, you said at that point, I would like an adjournment because I'd like to have an attorney.
standby.
Sir, you stated you didn't want to proceed on your own and you would like to have an attorney appointed, correct?
So I don't know
It's
if,
yes or no. Did you say that or not?
I can't answer that because I don't know if appointed has the same definition as standby.
Sir,
Because to me, when you say appointed, that means a lawyer speaking
Well,
for you and standing
until
for you.
he's, unless he's
Sir.
actually representing himself, Judge, I just want to say to the court, when I read that note, because it was late last night, what I then did is I emailed the court, the prosecutor, and I had then the supervisor, I forgot her name.
Maria.
Ms. Marad, I understand that. So counsel, are you telling me that I can't ask your client questions?
No, that's not what I'm just saying, like, I would like to advise him before he says anything. I wasn't present, and so I don't know, I don't want him to make a record that he's
I
in
understand.
opposition to anything that went on.
I understand. And Mr. Mohammed, I think, could shed a little bit more light on that as well, because Mr. Mohammed, in fact, agreed that Mr. Salem should have somebody represent him when we were here on the July 2nd. Is that something that occurred, Mr. Mohammed?
Yes, so Judge, basically at the hearing where the defendant initially represented that he wanted to represent himself and was in agreement to releasing his attorney at that time, I was not present for that hearing.
Correct.
At a future preliminary exam, considering the charges that I saw, which included felony firearm at that time, which is a mandatory 2-year prison sentence, it was based on my assessment that I wanted to make it clear for the record that there is a recommendation from my office that he have an attorney. We respect and he has every right to represent himself, but I just wanted to make it clear for the record that this type of a case, I think he should have an attorney because they're familiar with the rules of evidence and things of that nature, to ensure the best defense for the defendant. At that time, it was my understanding that he did request a attorney to be present. I don't know.
Correct. And I will interject one moment, and there's even a document signed by your client to that effect.
I can't speak for the defendant's exact intent in that moment of whether he wanted to just have someone on standby or at some point represent him. I don't know exactly what was going through the defendant's mind, but in both aspects, we're okay with him having a standby attorney or with the defendant having an attorney to represent him in its totality. So, and if the defendant wants to represent himself moving forward, again, we also have no objection, assuming it's done freely, voluntarily, knowingly. He has that right, and we're not going to have any position as to that. So whatever the defendant wants to do, as long as he is doing it freely, voluntarily, and knowingly, we have no objection to him representing himself, him having a court-appointed attorney, or him having a court-appointed attorney for standby.
And I think that that's where I sort of got confused, Judge, and I do apologize because I believe he has a constitutional right to represent himself, subject to, the court's sort of inquiry as to his understanding, et cetera, right? And so it does put me in a difficult position because I don't know what happened. I'm getting, I believe the court.
And in fact, I did inquire of Mr. Salem on June 11th when his attorney withdrew and he wanted to represent himself, because I asked if he wanted to have an attorney appointed to represent him when the court would have given him that the documents to fill out at that point. And he stated he wanted to represent himself. And I stated to him, Mr. Salem, you understand that you're expected to know the rules of law, the court rules and things of that nature, and the rules of evidence. I said all that, correct, Mr. Salem?
Yes, Your Honor.
Right. Then on July 2nd is when your client requested an attorney to be appointed. For whatever purpose he wanted the attorney appointed, I don't know, but it's his right to request an attorney be appointed. So this court allowed him to continue with his additional constitutional right to have an attorney represented to represent him. So that's what we did. So we're not doing the back and forth, sir. We're not doing the back and forth. I understand as well, Ms. Longstreet, that your office isn't necessarily appointed a standby counsel as far as not being paid for contract purposes or whatnot. So at some point, whenever that became known or became a subject of conversation, there potentially should have been a communication to the Appointed Services Division to say, hey, perhaps this has to be somebody else that gets appointed to represent Mr. Salem and not NDS. I don't know in that regard. But in any event, until there's a motion filed, NDS is the attorney of record. Well, and really it was Ms. Ridgway was the attorney of record prior to her being on strike. So, and Ms. Ridgway did in fact advocate and represent Mr. Salem last week regarding the new date that we had picked of today. So that's where it is.
You're going to adjourn this till after Mrs. Ridgway's return?
I don't know when that is. And I'm not adjourning this indefinitely. There have been 6 adjournments in this case.
Okay.
So Judge, let me just ask, and let me first apologize to the court.
You just happen to be the one that's here and you have to hear everything. from the court.
Yes, and I talked to my client yesterday, and we had some text messages so I could try to straighten it out. And there was even because I truly believe that he was pro se, right? That's why I know he sent a email or a letter to the court about a discussion that occurred between the prosecutor and himself on the phone. And I thought he was pro se, right? And the prosecutor asked me to get on the phone just so, because she believed he was representing himself, just so that, there's some cover, right? And
Right, because they shouldn't be communicating with him if he's represented. And there's an attorney appointed to represent him.
yes.
Correct.
And so where we're at now, I know very little about the case other than my discussions with the client. I did discuss with him this morning the fact that I believe he wants to represent himself, but I understand he just said, can we adjourn this till Ms. Ridgway gets back? So that's number one. Number two, he had a motion that he filed. It's my understanding that it was 2 days short of 7 days.
No, it was 2 days, 2 days notice, 5 days short of 7 days.
Notice. And so that violated the court rule. And I believe at this moment, he is asking that the prosecutor be given an opportunity to respond to his motion, that the court set this for another preliminary exam. The open question is whether or not it is with counsel, or he's representing himself, or representing himself with standby counsel.
Okay, so, before I give Mr. Mohammed an opportunity to respond, I'm going to state this. That, as I've stated, this matter's been adjourned 6 times. 6 times. For a variety of reasons. It isn't as though it's been, for the same reason each time. So one is because, retained counsel withdrew. Another time it was because, officers weren't available for the bond violation hearing, so the court just pushed everything together, which seemed to make the most sense. Then, it was adjourned because your client, requested an appointed attorney. And then it was adjourned, well, then it was set for probable cause conference. And then that ended up being, adjourned because your client wasn't present. And then July 16th, it was adjourned based upon the timing of the case being called at 5:37. And I didn't really want to provide everybody with food for dinner that night and stay here till 8 or 9 o'clock at night. So, so it isn't as though it was the same reason that it's been adjourned at all. In fact, I don't think it was a duplicate reason for any of it. I will state, however, that, the bond violation, at the very least, should be going forward today. We have officers from another jurisdiction that have been here on a number of occasions, one of which had to get coverage for a trial down in circuit court as well. That, counsel, I believe you can communicate with your client and the prosecutor about, and even review the video that the prosecutor has to decide what it is your client wants to do with that. And then I will determine what we're going to do with the exam after I hear from Mr. Mohammed.
Thank you, Judge. And Judge, just for the record, the video associated with the bond violation was previously shared with the Neighborhood Defender Service, the same office that Ms. Longstreet is part of. So that was previously shared prior to today's date. I will be objecting at this point and making my record as to any further adjournments of the preliminary exam. As your honor is aware, we've had our officers associated with the preliminary exam here every single time. This is, I think, the third, maybe the fourth preliminary exam if it is adjourned again. And so at this point, it's causing undue delay. I understand some of the times it had to do with scheduling and things being prolonged. And I understand all of that, but at this point, there's been a number of adjournments. We'd like to ensure efficiency with the court and with the movement of this case. I can't help but think at some point, this is becoming a larger play of some kind of a strategy to continue to delay.
Okay, we're not gonna go to that because Mr. Salem, in fact, said he didn't want it to be adjourned and was objecting to any adjournment because he thought that the prosecution wanted an adjournment. That was in his letter that he provided. We're not gonna go into trying to presume strategies or tactics, but you can.
But that's you're exactly correct, Judge. First, he says that he wants to move forward leading up to today and no more adjournments. He wants to move forward. But then now he wants to ask for an adjournment. So which is it? There's a lot of contradictions happening. And now it's starting to rise to, and I understand it's speculation, but I'm starting to get concerns. Is he truly asking for an adjournment that's supported by good cause? I guess is where I'm going with this. I ultimately always will defer to the court's discretion. Your Honor, I trust your judgment. You have a lot more history in handling these types of matters, but I do have to put the prosecution's position at this point that I believe any further delay is really being done unduly and could be supported by the lack of good faith. However, I'll trust the court's discretion and judgment as to that, but it is something I wanted to point out for your honor.
Judge, may I respond to that before we move to the next thing? Just so the record is.
Yes,
My understanding is that there was an adjournment because retained counsel withdrew. Don't know why that is, right? That happens. I don't know if it had something to do with the attorney-client relationship or fees, but certainly that's not necessarily something you can attribute to my client. Secondly, I did hear the court say that there was at least one day where all the parties were here until almost 5 o'clock. And
almost 6 o'clock.
okay, so almost dinner time and somebody would have been buying pizza. And I do understand and appreciate the efficient operation of the court, right? But I would say to the court, if out of those 6 adjournments, I don't necessarily know that you can subscribe any ulterior motive to my client at this point. And here, I think that there is a ton of confusion because now I'm probably the 4th lawyer he's seen. And in all candor, I haven't seen this video. I haven't read the discovery. I've had a discussion with him, but that's just a discussion, right?
Right.
And so, and I know how serious any hearing is as it relates to bond violations, right? So I am just asking the court to take all those things into consideration.
I will take those into consideration, but I'm also going to give you an opportunity to review the bond conditions that this court had. Mr. Mohammed, I'm going to have you share the discovery with Ms. Longstreet. I understand that you shared it with the Neighborhood Defender Services, but clearly Ms. Longstreet has only just been thrown onto this matter. So I'm going to have you provide Ms. Longstreet with that information, and we will resume in about at 2:30.
Your Honor, I would like to address something before we get off the record. Under FCR 2119, it also states that for good cause, my motion can be filed or be viewed and put on the record before the 7-day or set to the next available date. I don't feel that is fair. We go with a bond violation without putting my motion on the record because it will strengthen my defense. And there's a lot of information that needs to go on the record before my bond violation is set.
Sir, 2.119, it allows a waiver of that time with court permission. Does it not?
That's with good cause.
Does it state that with court permission? Did you request court permission?
I did not.
No, so that,
I am asking for it now.
sir, you do it when you file the motion.
My attorney didn't put me.
Let me deal with one.
And Judge, very briefly, if we are proceeding with a bond violation hearing, the defense has every opportunity to cross-examine witnesses and I'm sure some of the information that's, and I'm just speculating, but that's contained within his motion that relates to the bond violation, he can cross-examine witnesses and bring up information that's in his motion, I'm assuming, if it relates to the bond violation. So that's just our position at this time.
Okay, I understand. We'll resume at 2:30. He's still off the record. We did not sign that yet. Well, let's go on the record in the matter of the city of Michigan versus Mohammed Salem, 26586. And appearance for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Thank you.
Christine Longstreet appeared on behalf of Mr. Salem. Thank you for the time to talk with Mr. Salem about it.
You're welcome. And Mr. Salem, your your name for the record, please?
Mohammed Salem.
Yeah.
Okay.
Yeah, it gets
And
old.
so, counsel, as to the bond violation, you prepared to proceed?
Yes, Your Honor, I'm just gonna put two quick things on the record.
Okay,
There's been a misdemeanor offer, from the prosecutor. Improper transport of a
That
firearm.
is incorrect.
Am I saying it wrong?
Yes, the plea offer was a 90-day misdemeanor for a offer of obtaining a pistol without a license.
Thank you, sorry.
okay.
With some terms, probation, and some other conditions. Do you want to proceed and take that on?
No, because that would restrict me from my future employment.
Judge, I'm gonna object. We don't need to know the reason
I just-
why he doesn't want to accept.
Correct, and I don't need to necessarily know all of that background. If you'd like a few moments to speak with your client counsel, in the lobby regarding that,
I think
I can give you that time.
we've talked a lot about it and, I just wanted to make it clear, that the prosecutor has told me this offer is a one-time offer. It won't be available if the case goes downtown or goes further. And, want to make it clear before we proceed.
And Judge, I just want to clarify for the record, it was a district court plea offer only. The offer now is withdrawn and will not be reoffered in district court. We are ready to proceed with the preliminary exam and the bond violation.
Okay. All right, and so, we will proceed on the bond violation. The bond violation is, bond violation is alleging that Mr. Salem was in possession of a firearm. Okay, I'm not sure if you got into all this stuff. This was also, they didn't have correct.
Yeah.
Okay.
And they saw the bond, but
Got it. And, it is, let me just get to that.
Okay. Awesome. So you guys are stipulating the video? Yes. In your under, as a preliminary matter, when the court is ready, there are some stipulations.
Okay.
One specific one.
Okay, and let me finish my, okay. It is indicating that there was that the bond violation is that your client was in possession of a firearm, in violation of this court's order not to possess any firearms or any weapons.
Yes, Judge, we're stipulating that my client,
Well, Judge, I just would like to make sure there's a clear record.
Hold on, I run the courtroom, so I will give you both an opportunity when it's appropriate. So just one moment. So that is the bond violation that we are proceeding on, is the allegation that Mr. Salem was in possession of a firearm contrary to this court's order. So are the people ready to proceed on that matter?
Yes, we are, but before that, I guess I just.
Counsel, I will give I will give you both an opportunity if there's any preliminary matters. So you're ready to proceed, right?
I'm ready to, yes, you're
Okay.
ready to proceed on the bond violation.
Okay. Ms. Longstreet, are you ready to proceed on the bond violation?
I am Judge.
Okay, now, are there any preliminary matters that we need to address?
Yes, thank you, Judge. I'm just requesting clarification. Is this hearing is the defendant being represented by counsel during the course of this hearing, or is he going to be representing himself with counsel standby? Just because at this point, there's been a few different representations made to me that he was going to represent
Excuse me,
himself.
counsel, just one moment. When we resumed, Ms. Longstreet stated she was appearing on behalf of the defendant. So we are proceeding with Ms. Longstreet representing the defendant.
Okay. I have no objection.
Okay,
Assuming that's what he wants, I'm good with this.
And Judge, I was going to say that, sort of move this forward. Mr. Salem,
no, he told me it's Salem. I even wrote it phonetically on my file.
Everybody makes a mistake.
Mr. Salem is prepared to admit on this record that is him bringing a gun to the Southgate Police Department. I don't have the date.
So is he pleading guilty to the bond violation?
He's gonna admit to those things, and then we want to be heard as to the argument, then the court can decide. This prevents
Okay.
sort of,
So is your client pleading guilty to the bond violation and then wants to allocute as to any sentence of the court for the bond violation?
Guilty police officer testing.
maybe I should just stipulate to a certain series of things, and then I can put them on the stand, and then the court can make findings of that.
No objection.
Okay, all right. So what are the stipulations?
That on June 2026, that is Mr. Salem, entering the Southgate Police Department, and that he did in fact bring a gun there to surrender the gun. Is that satisfying?
Okay, so those are the stipulations on behalf of your client. All right, Mr. Mohammed, you're in agreement with those stipulations?
And Judge, yes, but I just see, are they stipulating to the make and model, which is a 6 or, and just for the record, it's spelled SIG, and then it's SAUER, model 1911 TACOPS?
Yes, for the record.
Okay,
And is the description associated with that weapons GS 95182/GS 95182?
When you say descriptions, you mean the serial numbers?
Yes.
So stipulated.
okay. All right, stipulate serial numbers. All right. Any other requests for stipulation?
Yes, I would just request a stipulation to people's proposed exhibit 1, 2, and 3. 1 is the Supermatch shooting sports receipt. 2 is a license to purchase a firearm, which contains license number 26113331994G-001. And people's exhibit number 3 is another license to purchase a firearm with license number 26113331194G-01.
So stipulated.
Okay,
And I
Alright.
move into evidence people's exhibit 1, 2, and 3. And again, just for the record, exhibit 1 was the receipt, 2 and 3 are the license to purchase firearm permits associated with some of the allegations and the bond violations in this case.
No objection.
okay. So admitted?
Admitted.
And respectfully, I would ask the court to review those documents.
All right, so you're requesting to publish?
Yes, thank you.
All right, the exhibits are admitted and published based upon stipulation. Okay, the court has reviewed, people's exhibits 1, 2, and 3. And, are people calling any witnesses?
Yes, 1.
You may call your first witness. Let me just ask this other question. Are there any other witnesses in the courtroom that will be testifying as it relates to the bond violation?
Yes.
Some of us,
So,
for the people.
Your Honor, since the defendant stipulated to that being him in the video, there will be only one witness called for purposes of the bond violation, and that is Detective Michael Murphy from the Southgate Police Department.
Okay, so my question still stands. Are there any witnesses in the courtroom that the people maybe want you to call as a witness for the bond violation? Or even in the preliminary examination that could be affected by any testimony here today?
Detective Klanowski is associated with the bond violation, however, I will not be calling him to the stand, but I'll ask him to exit the courtroom.
Okay,
And Officer, I'm sorry, how do I pronounce your name? Officer Simoniak from the Southgate Police Department is also associated with a bond violation. However, I will not be calling him to the stand, but I will ask him to exit the courtroom as well.
Okay, thank you. Yeah, I'm sorry, can you please spell the last name of the officer?
Yes, Simoniak is spelled F as in Sam.
I'm sorry, just a moment, just so you know, your microphone's on, counsel, there, and so it's affecting the record, just so you're aware.
Your Honor, the
No,
officer.
don't, no, it goes right into your ear when you touch it. Okay, I'm sorry.
Thank you. The officer's last name is spelled S as in Sam, Z as in zebra, Y, M, O, I, Moniak. And I'll repeat that just for clarification. S, Z, Y, Moniak.
Good thing I had you spell it. I don't think Alicia would have gotten that. Okay. All right. And so the court will ask you to please step out for purposes of testimony. And Ms. Longstreet, are there any witnesses for the defense that are in the courtroom that could testify in this matter?
Samuel Salem, can you please step out and?
Okay. All right. And then there's one other individual in the courtroom, but she's not expected to testify. Is that correct?
That is correct, Your Honor.
Okay. All right. And so, counsel?
Yes, for our first witness, Your Honor, the people would call Detective Michael Murphy from the Southgate Police Department.
And Alicia, the person in the waiting room is a Southgate detective, so we're gonna do an arrangement. All right, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
All right, thank you. Please have a seat. You may adjust the microphone and please state and spell your first and last names for the record.
First name is Michael, Michael. Last name Murphy, Murphy.
All right, thank you. Counsel, you may proceed.
Thank you. Detective, are you currently employed?
Yes, sir.
And how are you employed?
I am a detective sergeant with the Southgate Police Department.
And were you employed in that capacity as a detective with the Southgate Police Department on June 23rd, 2026?
Yes, sir.
And on or about that time, did this specific case come to your attention at some point?
Yes, sir.
And how did that begin?
On June 23rd of this year, I learned that our Southgate Police Department Records Office received a copy of a pistol purchase permit was mailed to them by CC Coins and Pawn out of Wyandotte. That copy of the pistol purchase permit showed that Mr. Salem purchased a AR-15 pistol from CC Coins and Pawn on May 19th of this year. An issue with that pistol purchase permit, it has an individual license number affiliated with that, and that license number had already been used for another pistol purchase permit for Mr. Salem on May 19th as well, and that was from Supermatch Firearms Dealer. Nice. Out there.
I'm sorry, what was the name of the CC what?
Coins and Pawn here in Wyandotte.
Okay.
3 minutes, yeah. And Your Honor, may I approach the witness?
You may.
Thank you. Detective, I've handed you what's been introduced in the evidence as People's Exhibit 1, 2, and 3. I'd like you to take an opportunity and review those 3 exhibits.
Yes, sir.
Have you reviewed those 3 exhibits?
Yes, sir.
Do you recognize those 3 exhibits?
Do.
And how do you recognize them?
Exhibit number 2 was the copy of the pistol purchase permit I became aware of on June 23rd for the AR-15 pistol from CC Coins and Pawn. Exhibit number 3 is a copy of a pistol purchase permit I just noted from Supermatch, in which the Sig Sauer was purchased in Mr. Salem's name also on May 19th. And exhibit number 1 is an invoice for that pistol purchase permit for the SIG from Supermatch.
And did something about those 3 exhibits, and is that a fair and accurate depiction of what you observed previously?
It is, sir.
Does it appear to be altered or manipulated in any way?
It does not.
And what about those 3 exhibits drew concern, if any?
As mentioned, the license number on each of the pistol purchase permits is the same. It was supposed to be for one single purchase of a pistol.
And can you provide some background to the court of why that drew concern? How does it typically
I'm
work?
gonna ask, what's the relevance? We're getting into, the fact that he said he purchased multiple guns. This is a violation here.
The relevance, counsel?
Well, Judge, I guess my concern at this point is if the defendant is using duplicative purchase permit. So when you get a purchase permit, you get it with one license number. How, I guess it's had the same license number is being used to purchase multiple weapons.
What does that have to do with the guy?
So if there's been some sort of a copy of a purchase permit when it was blank and now you're using that same purchase permit to purchase.
Okay, but counsel, how does that, if the bond violation is that Mr. Salem was in possession of a gun, contrary to the court's bond order, what does the license or multiple licenses or possible multiple licenses have to do with that? Mr. Salem's, there's been stipulation that he brought the gun in there and that, that is him on the video. He stipulated to the make and model of the gun and serial number. So I'm not sure how the licenses are relevant for purposes of the bond violation, the multiple licenses. I can see that the date would be significant, but it doesn't appear as though the balance of what the testimony is at this point for this issue is relevant. So the court's going to sustain the objection.
Understood, thank you. Sir, what did you do next? How did you further your investigation?
I opened an investigation following up on what was believed to be the fraudulent use of a pistol purchase permit. To provide a calendar timeline of events with that subsequent investigation, on April 23rd of this year, Mr. Salem obtained a valid pistol purchase permit from the Southgate Records Office that would be good for 30 days. On May 7th would be the date of this year that Mr. Salem was arrested by the Wyandotte Police Department for CCW of a pistol. On May 8th, that following day, he was arraigned and given the conditional bond not to possess firearms or weapons. Next date coming into play would be May 19th, which would be the date each of two pistols were purchased and confirmed at two different firearms dealers. One being the 6 Sauer from Supermatch, which was confirmed by our records office in Southgate, both over the phone and sent by email, which would be this invoice, which is exhibit number 1. The second pistol purchase permit, the AR-15 purchased by CC Coins and by Mr. Salem at CC Coins and Palm, I confirmed over the phone with CC Coins employee Brandon Donaldson. On May 22nd, learned in my investigation, our Southgate Police Department Records Office also received an NCIC notification that Mr. Salem had been denied purchase of a long gun.
Judge, again, what is the relevance of attempted purchases? I mean, I assume this is the officer of Southgate. I think the dates are relevant, but all these additional details?
Well, you're correct. This is the officer from Southgate as stated at the second question. And what is the relevance to that date of, I'm sorry, you said May 22nd?
Yes, sir.
Okay, what's the relevance of May 22nd date?
Mr. Salem.
No, sorry, hold on, not you, officer, sorry, or detective. Mr. Mohammed, what's the relevance of that?
So, Your Honor, my understanding is, the defendant in this case was arraigned on May 8th. And as part of Your Honor's orders, you ordered for the defendant not to be in possession of any firearms and to turn over any weapons to the police department. I believe that the officer's investigation which led him to identify that there was an attempt to purchase weapons despite the court's order not to possess, I think is very relevant for purposes of Your Honor's determination. It goes to show his intent, whether the defendant is going to comply with Your Honor's order. I think an attempt to make a purchase is relevant for Your Honor to consider.
All right, the court's going to overrule the objection as to that testimony at this point.
Thank you. Go ahead, sir.
And then on June 5th, the Southgate Police Department Records Office received the first of the copies of the 2 pistol purchase permits. The one noted for the Sig Sauer, which was purchased at Supermatch. At that point, the police report was written, that purchase was confirmed, and Mr. Salem was contacted by our detective lieutenant regarding that gun. On June 6th, the following day, Mr. Salem stepped into the Southgate Police Department lobby in the video and surrendered that gun that he had purchased at Superman.
Thank you, sir. And you referenced the video. Had you, prior to today's date, had an opportunity to review the video associated with the defendant turning over one of the firearms?
I briefly saw it.
And do you believe that if you were to observe a short portion of that, you'd be able to identify that video?
Yes, sir.
I'd like to draw your attention to the screen. And Your Honor, actually, I believe there's a stipulation with defense counsel to admission of this video. I'd like to introduce, pursuant to stipulation with defense counsel, People's proposed exhibit number 5. I recognize I skipped a exhibit number, which would have been 4, but it's already been pre-marked for a different future exhibit.
All right, and Ms. Longstreet, is there a stipulation in the video?
So stipulated.
Okay, thank you. And are you on your phone for this purpose, counsel?
Yes. What do you mean?
Your phone. I see you're on your cell phone. Are you on your phone for this case or something else?
Something else, sir.
Please do not do that.
Yes.
I don't know.
You may proceed.
Thank you, Your Honor. And just for the record, this video is labeled inside the video as PD West Wall of Lobby dash 06/06/2026. And it has a timestamp of 3/21/14.832 p.m. I'm requesting to publish at what appears to be 3 p.m. and 3:23 p.m. with 23 seconds. Publishing now.
Okay.
Pausing at 3:24 p.m. and 19 seconds.
There we go. We finally get to see it, and it was worth the wait.
Detective, are you aware of what occurred in this video?
Yes, sir.
And what did you learn after reviewing this video and as part of your investigation?
That on that date and time, Mr. Salem turned over the noted Sig Sauer in evidence over to Lieutenant Simoniak.
Thank you. No further questions from the people. Thank you.
All right, thank you. And for the defense.
Officer, you asked Mr. Salem to bring the gun in and surrender it?
I
Okay,
did that.
I'm sorry. What was that, counsel?
I'm sorry. You asked Mr. Salem or someone in your department asked Mr. Salem to bring the gun in, and surrender it, correct?
Detective Lieutenant Klinowski did.
Yes, and he did so.
Yes,
Promptly.
the following day.
Your Honor, I would object at this point, only because I think this goes to lack of personal knowledge. Detective Klinowski is present. He's outside the court. If defense counsel would like, I have no objection to her calling him as a witness to ask him directly as to what he said. So that's our position at this point.
Your response, counsel?
Judge, my response would simply be that he just testified that that was Mr. Salem turning in the gun, right?
No, when he testified, well, I'm talking about the objection to what Detective Lieutenant Klinowski asked your client. That the objection is to that question because Detective Lieutenant Klinowski is present. And Mr. Mohammed stated that his objection was that this witness may not have the proper information on that and that Detective Lieutenant Klinowski would be the best person to ask that question of. Is that your objection, counsel?
Yes, correct, Your Honor.
Okay.
Well, okay, Judge, since he answered it, can I try to lay a foundation to see if he knows and how he knows?
You may, okay, so the court's going to sustain the objection, strike the answer. I will allow you to lay a foundation.
Thank you.
Okay. Officer, did you ever have any contact with Mr. Salem?
I don't believe that I did.
And so you aren't the officer that retrieved the weapon?
Correct.
And that was Officer Legowski.
Lieutenant Simonek.
Okay, Lieutenant.
Lieutenant Simonek is the officer for Southgate. They're taking the surrendered weapon.
Okay,
And if there's confusion with names, I apologize. Detective Lieutenant Klinowski would be another representative of our police department that's here.
nonetheless, you know that that weapon came into possession, right?
Yes, ma'am.
And if you have personal knowledge, do you know what day that was?
The date that it was surrendered, is that what you're asking?
Yes.
June 6th of this year.
Okay, and do you know what time?
I don't know specifically.
If you refresh, the court as to when this weapon was purchased,
May 19th.
pardon me,
May 19th, 2026.
the weapon was purchased May 19th, correct?
Correct.
And was that before or after? Just 1 second, that's all.
Yes.
That I took delivery.
Mhm.
Leaving my son back to the 19.
Sir, you might want to speak
I know,
on a lower level.
I have no more questions of this.
Okay, thank you. Any redirect?
No, thank you, Judge.
Okay, thank you very much. You may sit down, please. You don't discuss your testimony with anybody.
Thank you, Your Honor.
People have any further witnesses?
No further witnesses, thank you.
Okay, thank you. And, Ms. Longstreet? Thank you.
Judge, Mr. Salem would like to testify.
Okay. But, I'll have you,
Oh, here we
step over
go.
to the witness chair and actually, I'm gonna have you maybe pause for a moment. I have to do an arraignment for Southgate PD and a bedside arraignment. So we're going to take a brief break on that. We're gonna handle that matter and then we will resume with this one, okay?
Is it okay if I step out?
Well, yes, that's fine. And counsel, if you want to have a conversation with your client in the lobby, we can certainly do that as well. Okay. Is the attorney present and did they are to speak? Okay, Mr. Mohammed, I need you to stop screen sharing actually, let's. Can you stop the screen sharing for a moment? No. Can you, however, I just need somebody to, all right, so let's go back on the record in the matter of, a recall in the matter of the state of Michigan versus Mohana and Salem, 26586. Bridge for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Christine Longstreet, we're going to be having Mr. Salem.
Your P number, counsel.
Sorry, P 5299.
Okay, thank you.
That's it.
All right, thank you. All right, and so, counsel, you have called your client to testify. And so, Mr. Salem, I'm going to have you step up here to the witness, please. All right, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, please have a seat, speak directly into the microphone, and state and spell your first and last names for the record, please.
I'm on J-O-N-E-D, last name is S-A-L-I-M.
All right, thank you. You may proceed.
Good afternoon, Mr. Salem. At some point, did you purchase, 2 firearms?
Yes,
The reference firearms, from court today?
yes,
What do you need to purchase a firearm?
purchase permit,
Okay. Did you obtain a purchase permit for those 2 firearms?
yes.
What date did you obtain the purchase permit?
I believe it was the 23rd of April.
Okay, that would have been before your arrest, correct?
Correct.
Okay. Is there an expiration date on the purchase permit?
Yes. 30 days.
So, do you have a purchase permit
Okay.
for the firearms that you purchased?
Do I have them now?
Yes.
No, they were unlawfully taken from me.
Your Honor, my apologies. I would like to excuse the 2 wind-out officers because at this point, because the defendant is testifying, I think it could, some information could come out that would associate them, so
Okay,
in the interest of that, asking to step out.
okay.
Thank you for that.
All right, thank you. And so the court will note for the record that both the officers, the wind down officers have left the courtroom.
Thank you. So you don't have the permits, but in order to legally purchase firearms in the state of Michigan, you need a permit.
Correct.
And it expires.
You don't have a CCW
All right.
or CPL, I'm sorry.
And you obtain that permit. Did you then take those permits somewhere to purchase a firearm?
Correct.
Would that be,
Hold on, let me, before we proceed. I think it's prudent of the court to advise Mr. Salem, because he is testifying in this matter, sir, that, you do realize, sir, that you do have the right to remain silent, and that anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
You understand that it could be used against you in your pending felony matter. Do you understand that?
Yes.
Okay, I just think that it's clear that the record reflects that Mr. Salem is aware of that, and that anything he testifies to here today could be used against him for any further proceedings, possibly.
thank you.
Okay, thank you. Are the people satisfied with that?
Yes, Your Honor.
Thank you. And Ms. Longstreet, are you satisfied?
I am not.
I think you may proceed.
So after you obtain those permits on April 23rd, did you then go somewhere to purchase a firearm?
Yes, there were firearms that I put on layaway.
Okay. And are those the same firearms that are the subject of today's hearing?
Yes.
Okay. Where did you go to purchase the firearm?
Supermatch, Shooting Sports, and CC and Coin.
Okay. Do you recall what day you actually purchased them?
I believe one of them was, I want to say the last week of April, maybe the 26th or the 27th, and I do know that the one from CNC Coin was the couple days prior. CNC Coin, maybe the May 1st or 2nd. I don't know the exact date.
I object. The defendant keeps using words like "I believe," and it sounds like he's speculating at this point. So based on that, I'm going to object. The legal objection is speculation. The words he's using, and he's giving multiple dates, it doesn't sound like he's sure. So I think that should be struck from the record.
Okay, your response, counsel.
Judge, I think that it's up to you to determine how you accept the testimony. He's not solid on the dates. I'm going to tie it all up.
Okay, so what I'm going to overrule the objection for right now. Mr. Salem, if you don't know the answer to something, you can state you don't know the answer. If you are unsure, state that you're unsure. Your attorney will then do whatever she needs to do to that event or to that end if she needs to lay a foundation or otherwise. But if you can't guess, that's not appropriate.
So I apologize. It just been.
No. It's not an opportunity for you to respond to the court. That's the order of the court. Next question, please.
Thank you, Judge, for that instruction.
Okay, let me ask it another way. You're sure that you obtained a permit to buy these firearms before May 8th?
Yes,
Okay, you're positive about that?
100%.
You're positive that you went to both of these stores to buy those firearms before May 8th?
Correct.
And in order to do so, you had to obtain a permit, correct?
Correct.
And you had to obtain that permit before May 8th. Is that fair to say?
Yes.
And when you went to purchase these firearms before May 8th, did you leave the store with those firearms?
No.
Okay. Are you absolutely sure that at that time you did not leave the store with those firearms?
Yes, a background check has to be run thorough since I don't have a CCW or CPL. CPL, you cannot leave with the firearm until government clears them.
Okay. And at some point, did you find out that the government cleared those firearms?
Yes, the store called me.
Okay. Was that before or after May 8th?
One of them was before, one of them was after.
And what's significant about May
That was when my bond restrictions were set.
And so your bond restrictions were set on May 8th. Were you at some point released from custody?
On the 11th,
And did something happen after you got released from custody that made you go to the store where you originally purchased the firearms?
yes.
And do you know what day that was, that you went to the store to retrieve the firearms?
The 19th,
Of
May.
May. How do you know it was May 19th?
It's a date on the purchase permit.
And when you say it's the date on the purchase permit, what do you mean by that?
The date is written when you, not when you purchase them, when you take delivery of them.
So is it fair to say that you purchased some firearms, put a deposit, and you didn't accept delivery of them until the May 19th? Is that fair to say?
Yes, but I physically didn't accept possession of them, but.
So wait,
Yes.
we're gonna be there.
Okay.
So you go to the store. What prompted you to go to the firearms store on May 19th?
They called me and,
Okay, let me stop you there. You can't say that. Use the name of the store.
Supermatch called me and told me that my, purchase permit was going to expire, that I needed to, come and get them. I'd have to apply for a new purchase permit and start the whole process over.
Okay, because that permit that you have for 423 expires, right?
It would have, correct.
Did you go alone or with someone to Supermatch?
I went with my son to Supermatch.
Okay. And when you got to Supermatch with your son, what in fact did you do?
Made sure that my son had possession of the gun and he dropped it off at, a friend of ours named Christopher Murphy.
And why did you do that?
Because I'm not allowed to have any possession of any firearm.
And was there another condition of bond with respect to the firearm?
That I couldn't purchase them.
But you had, is it fair to say in your mind, you had already purchased these?
These were already paid for.
Do you recall that a condition of the bond is that if you had any firearms, that you were to turn them over
Correct.
to the police?
Yes.
Did you do that?
I returned the SIG, the several others that I had at the time, my attorney,
Well, I don't want to get into what
okay.
anything your attorney said, but based on, don't tell me what the attorney said, based on what your attorney said, what did you do?
Get rid of the weapons.
When you say get rid, you don't mean you toss them in the river.
No.
Are you saying that you put them somewhere for safekeeping outside your possession?
I sold them to recuperate the bond money and attorney fees.
Okay, so you got rid of the firearms to get the money that you spent on bond back, right?
And attorney fees, yes.
I'm not ready to watch this, thank you.
Okay. Mr. Mohammed?
Thank you, Justin. You were prior to that date of the weapons on May 19th, going to the store with your son, as you state, were you arraigned in this case?
Yes,
And were you aware of the bond conditions associated with the arraignment?
yes,
And were you aware of the condition of not to possess any firearms?
correct.
And is it your representation here under oath that you are aware of all the conditions the court had imposed on that specific day?
That's exactly why I didn't possess any.
It's yes or no, sir.
Yes,
Thank you. And is it your testimony here today that on May 19th, you went to the Supermatch shooting sports store with your son to pick up the firearm, correct?
correct.
And at that time, had you obtained or been in possession of a license to purchase? A license number associated with the firearms in question?
They had, you talking about the purchase permit?
Correct.
Yes, it was with the gun store.
How many purchase permits did you have with you at the store?
I want to say about 3 or 4.
And you had an opportunity to review with your attorney present the two exhibits, People's Exhibit 3 and People's Exhibit number 2, prior to its introduction, correct?
I don't know what those exhibits are.
Your Honor, may I approach the witness?
Yes. With what are you approaching him with?
A copy of People's Exhibit number 2 and People's Exhibit number 3, and I've showed it to defense counsel.
Yes.
Thank you.
Thank you.
Sir, I'd like you to take an opportunity and review those two exhibits.
Okay.
Have you reviewed them?
Yes.
Your Honor, may I approach and recover the two exhibits?
You may.
And, sir, those two exhibits were stipulated and introduced into the court today. At that time, did you review those two exhibits with your attorney present prior to its admission?
With the little time we had, correct.
Sir, would you like additional time to review the two exhibits?
You guys will grant me another motion to.
Sir, it's yes or no, and it isn't as though the prosecution did not grant that. It's the order of the court. So the answer is yes or no.
I don't need more time.
And so is it your testimony here that you have reviewed it and there's no more, you don't need any more time to review it, correct?
No.
Okay, and did you observe any observations or writings on these exhibits that you stipulated to that were incorrect or inaccurate?
There is some hold on. Rephrase that. There is a mistake with the paperwork.
So is it your testimony here that you had observed mistakes on the paperwork but still agreed to introducing it into the record pursuant to a stipulation?
I didn't. I don't know how to answer that properly.
It's a yes or no. Is it your position that you agreed to introducing these two exhibits despite being on knowledge of mistakes
Judge,
from your assessment?
Yes. What's the objection?
I want to make objection. We agreed to the stipulation, whether or not it stays on them is irrelevant. We agreed that they get admitted into evidence, not to their authenticity, not to whether they're all correct.
All right, and so your response to relevancy.
Judge, number one is cross-examination, so
I'm aware of that.
No,
I need to know what's the relevant portion
well, Judge, I'm
of
attempting to.
that testimony.
Well, I'm attempting to impeach the witness, and so I don't want to get ahead of what I'm going towards, but Judge, on the two documents that were admitted into evidence, there is a purchase/transfer date, which is dated 5/19/2026. Additionally, it also includes a purchaser signature, which appears to have the defendant's signature. So I was trying to get to where he sees these mistakes on these documents to see.
Counsel, I appreciate that. The objection is relevance as to whether or not the mistakes are relevant to these proceedings here regarding the bond violation of Mr. Salem having possessed or had access to the firearms. How is that relevant to the bond violation?
Because this document shows a purchase date of the firearm in question.
Of May
It's after the, yes.
Right, that's already been stipulated to. I can review that. My question is, the objection is, what is the relevance of whether or not Mr. Salem knew that there were mistakes on there and still stipulated for the additions? That's the question.
I understand. Now, Judge, it goes to his credibility. So because he's taken the stand, I'm attempting to also attack his credibility because he's now saying that there's mistakes versus earlier saying he was stipulating and saying, okay, I'm okay with introducing it. It shows a sense of credibility issues because I can appreciate that, counsel, but for purposes of the bond violation hearing, I don't
need those exhibits, to assess the credibility at this point. So the court's going to, sustain the objection regarding the relevance.
Thank you. Sir, you indicated on direct questioning by your counsel that you had gone to Supermatch Shooting Sports to pick up the items, correct, with your son. Is that correct?
Yes,
And on that day, you possessed the firearms with your son. Is that correct?
I did not possess them.
Okay, and so what happened when you and your son went to this? But earlier you indicated that you had gone with your son to pick up the weapons.
My
correct?
son took possession of them.
And how did you and your son arrive to this Supermatch Shooting Sports store? Was it in one car, different cars?
Different colors.
What car did you arrive in?
I don't recall.
You don't recall the vehicle that took you to the location, but you recall who you went with?
I have one vehicle. I'm not sure which one I drove that day.
How many vehicles do you have?
4?
And you're registered, and are all 4 vehicles registered to yourself?
No, not a single one.
Okay. Do you recall what type of vehicle your son went with in?
Probably one of his cars.
Well, sir, you mentioned the word probably, and I'll respectfully ask you to testify to what you know, not what you think.
In one of his vehicles.
I'm sorry?
In one of his vehicles.
Do you know what vehicle your son went in?
I don't recall.
Do you know whether or not the vehicle he went in was his?
It was in his name. He has
What's
3
the
vehicles.
relevant?
Hold on, just one moment. There's an objection.
This line of question, if the son got there, went there in a car that was his, or the issue is whether or not the son came with him and took the guns.
Okay, Mr. Mohammed,
Your
the
Honor.
objection is relevance.
Your Honor, the witness has testified to some dates in this case, and I think as Your Honor is aware, the dates associated with this case are very important. For example, the arraignment date, the date he went to the
I
store.
understand. How is, what vehicle his son drove important? How is that relevant?
Well, again, it's the details. I think it's showing that this individual, the witness that's testifying under oath, is speculating to a large portion of what he's saying, especially the dates. He can't recall simple facts like what type of vehicle he went in.
Okay. And counsel, I will just remind you, this is a bond violation hearing, not necessarily a trial or of sorts. So I don't find that, and I can appreciate, paying attention to details. But for this purpose, I don't find that that's relevant for the bond violation purposes. So the court's going to sustain the objection.
I understand. Thank you, Judge.
You're welcome.
Sir, during direct, you mentioned the word CPL, and so I guess my question is, are you in possession of a CPL?
No, I do not have one.
Have you ever had possession of a CPL?
No.
Sir, you had an opportunity to review People's Exhibit number 1, correct? Which is and I will approach you with permission from your counsel and the judge. Your Honor, may I approach?
Yes, with exhibit, which,
People's Exhibit number 1
One
is a
second.
copy of the Supermatch Shooting Sports invoice.
okay,
Yeah, the back. That's not my invoice. Improper dates right on it.
Sir, do you recognize the invoice?
That you gave to me, correct?
You do recognize it. How do you recognize it?
You gave it to me last week.
Was that the first time you've ever observed a copy of the invoice associated with a Supermatch Shooting Sports, which includes a shipping method to yourself, and it goes on to include a specific address and phone number?
Correct.
Sir, I'd like you, Your Honor, may I approach the witness?
you may.
Sir, briefly, I'd just like you to take a look at that exhibit and focus on the top left corner where it includes an address and a phone number. Do you see that?
So where's the
Yeah,
shipping method?
excuse me, sir, it's yes or no?
Yes,
Okay.
Is that your address and phone number?
yes,
And sir, during your opportunity to review that exhibit, which was stipulated to, did you observe the area where it has a description of the firearm in question? And is it your position that that is the firearm that you had recovered with your son, when you both went to the store?
it's the same model number, but the date on that receipt does not align with the 19th. So I find that receipt cannot stand any adherence in court because it's not a valid receipt. That was the day after.
Okay, and sir, I can respect your position. But my question is this a fair and accurate representation of the description associated as well as your name and address on the invoice?
That's not what the receipts look like from Supermatch. I have receipts with me from Supermatch and they don't look like that.
Sir, my question is the information associated with your address as well as the description accurate, that portion specifically?
The address for the purchaser is correct. Where it says shipment, there's quotations and nothing stated after that, so it was not shipped. And the phone number is correct. The model number of the firearm is correct. I did not see the serial number on that paper and compared it to agree to that.
Is the price associated with the purchase accurate? Okay. And are you familiar with a McKenzie?
Yes,
And who's McKenzie?
one of the attendants there.
And is that the attendant that you had made contact with at the time of the purchase of this firearm?
Not on the 19th.
Who did you make contact with on the 19th?
I don't recall their name.
Did you observe the firearm, the 6 Sauer? Did you observe that firearm on that day?
It was the case, he had
It's
on the table.
Respectfully, sir,
No.
yes or no?
No,
And I draw your attention to the video that was introduced earlier. You stipulated to that introduction, correct?
yes,
And that was you in the video, correct?
correct,
And that was you who had that bag in your hand, correct?
correct,
And that was you who turned over that bag to the officer, correct? And inside of that bag was that firearm, correct?
correct,
And that firearm was the 6 Sauer, correct?
correct,
And that 6 Sauer was the model 1911, correct?
correct,
And that's the same firearm that's associated with the purchased firearm, correct?
correct.
And that's the same firearm that's associated with the Supermatch shooting sports invoice, correct?
I don't know that. The date on that is wrong, so you cannot place me at that location at that date to accompany that invoice. We
Sir-
were not there on the 20th, so that receipt is meaningless.
Sir, you indicated that you and your son had gone to the store on May 19th to pick up the firearm, correct? And is it your testimony here that your son took possession of that firearm?
Dropped it, so correct.
It's yes or no. Is it your testimony that your son took possession of that firearm? And you had both made that location in different vehicles,
Yes,
and you had not observed that firearm.
no,
It's your testimony here under oath that
It's arguments.
Your response?
Well, Judge, number one, respectfully, I would say this is cross-examination. Number two, I don't think anything I've posed to the defendant was argumentative. It seems that he's agreeing with all my questions. So respectfully, I would disagree with the defense's position, but I'll defer
The
to.
court would agree, the court, it seems, it may seem, it's a bit of peppering of questions because it's a question and answer pretty quickly. But, the court doesn't find that at this point it's argumentative, so the court's going to overrule the objection.
Thank you, Your Honor. Third, your testimony that your son had taken the firearm,
Okay,
correct?
this is asked and answered, Judge. That's, I think, what I meant when I said argument. This is the third time he's asked about his son picking up the firearm.
Okay, so the court will sustain that.
Understood.
Okay.
Sir, do you know what your son did with the firearm after you both had gone to the store and he had picked it up?
He dropped it off to Christopher Murphy, who was a witness that was here multiple times and couldn't make it today. but he
Okay,
did.
so Christopher Murphy, that's the answer. Christopher Murphy. Next question, please.
And sir, when your son went to pick up the firearm from inside the store, what did you do?
I walked with him.
And so is it your testimony that you walked inside with him to pick up the firearm? Yes or no?
Yes.
And you did that together? And you walked out together?
I think he left before me.
You indicated, I think. Are you guessing or are you positive of that testimony?
Can I explain it?
Sure, go ahead.
So when I was there was other firearms that I currently had deposits on and stuff. So I believe I stayed to settle that with them to see what I have to do, whether I can receive from some money and how to handle that moving forward. And Christopher lives about an hour and a half from where we were. Pretty sure my son. I can't tell you exactly if he left with me or we both walked out at the same time. This has been 4 months ago going on. I'm sorry, I don't have the answer for you because I don't recall.
Well, thank you. I
Unfortunately, I
appreciate
don't.
the honesty and the transparency that you don't
Never had
recall. So I
contact with them.
appreciate that very much. So my next question is, you indicated that you had other firearms at that location, is that correct?
That I had deposits on
And where were those firearms?
behind the counter and they're safe
And where are those firearms now?
with them still.
How many firearms?
Judge, I think we're getting away from the relevancy of whether or not he was in possession of a firearm after a court-ordered bond condition.
Your Honor, if I may respond.
You may respond.
Thank you. Your Honor, I had an opportunity with defense counsel present to review the bond conditions in this case. And Your Honor, what I saw that it was not only that the defendant could not possess firearms, but it also included a sentence, which I assumed was written by Your Honor, to turn over all firearms to the police department for safekeeping. If my recollection serves me correct. So again, Judge, I think we're diving into this bond violation, but there's more that meets the eye, and there might be more it's not just that he may have purchased firearms, but it seems that he may still unlawfully possess firearms.
Well, okay, I'm going to overrule the objection for the sole purpose of knowing the date those deposits were made.
Okay.
That's what this court would find relevant.
Sir, do you recall the dates associated with the deposits of those firearms?
Not off the top of my head.
Do you know whether or not that was before or after the arraignment in this case?
They were all before the arraignment.
Sir, the testimony by the officer that you were present for suggested that there was an attempt to purchase a firearm. Are you familiar with that?
It wasn't an attempt to purchase. It was after I traded, there was a remaining balance I had on a gun that they were, I guess their process is to, in order for them to clear it, to take it out of my sale, because I explained to the people there that I could not possess it. I wanted my money back. So they had to submit it to see if it gets denied. And once it gets denied, you get your money back. And they returned to me $1,000 cash. And it was a Beowulf 50 caliber rifle. It was long gun.
So, sir, did you trade any firearm after the arraignment of this case?
I sold.
You sold firearms. Who did you sell firearms to?
See, and super my son.
Recognize that you did that after the arraignment in this case. And you were present at the arraignment.
Correct.
And you were aware of all the conditions the bond.
Yeah, this isn't close. I don't know why it's taking so long. You violated bond conditions. It's not a close call in any way, shape, or form.
That time, correct? Can you explain why you sold weapons knowing that the court had ordered to turn over weapons to the police department?
My attorney at the time, Matthew Savage, said that I have a legal right to sell my assets for money in a situation like this.
Okay, so, sir, I guess my question is,
And so if I could finish,
go ahead.
every step I made with the firearms that I purchased and the ones that I've sold, I contacted Miss MSP and I asked for the proper steps to be handled.
You said you contacted Miss MSP?
As you can say, police, so I knew how to pick up the firearms, how to sell the ones I had, not to have them in my vehicle, eliminate them from my home. Because nobody here gave me the steps on what to follow. So my lawyer told me that it would be smart to call MSP, and I called MSP, and when ATF came here, they were trying to indict me with ATF stated that I did everything textbook correctly, the justice.
Sir, respectfully, I'd ask you to testify to only
I
state.
explained it.
I know, but there's rules associated with hearings, and I just ask you to, respect those. Because I recall that at a previous hearing, you had indicated to the court, and correct me if I'm wrong, that you're familiar with the rules of evidence, correct?
Not the rules of evidence.
Okay, what are you familiar with? Please.
Okay.
We're getting outside the scope.
I understand. I would have.
All right, so next question, please.
So, sir, why did you not turn over the firearms to the police department since you were aware of the judge's order?
When I was in custody, my wife had borrowed money from several people. And I wasn't there to help with that, so we didn't have any money, so the first thing you do is you sell your assets. I didn't just sell the firearms that I had. I knew that firearms were metal and replaceable. I sold the vehicle that I had. I've been struggling financially since this, so I let a lot of assets go, and fortunately, firearms were the first thing that I did not need in my life, and those were the first to go. With consent of and permission of my lawyer, saying that I wasn't violating any laws, and MSP guided me in the process to sell these weapons and to pick up weapons that I further sold and turned into you. And I believe that if I should have been in any possession of a firearm, as if you're trying to pin a situation on me, Southgate Police should never have asked me to put the firearm in my car and drive to the police station and then charge me with conducting traffic.
Sir, respectfully, again, I'd ask you to just not state what another person said, the rules associated with that, okay? Correct. Thank you. So, sir,
So the law doesn't apply to me. They're just suggestions that I'm free to ignore it at will, and I can just do whatever the hell I want anyway. Okay.
is it your testimony that you recognize that you did sell weapons and possess weapons after the court had imposed its conditions, correct?
Lawfully, yes.
Well, that's.
Yeah, it's yes or no. We don't need any adjectives or adverbs added onto that. Yes or no?
Yes, that question again?
You recognize that you were in possession and had sold weapons after the arraignment in this case, yes or no?
Yes.
And you understand that you did not have permission of the court at that time, correct?
Is that a yes or no question? Because I don't know how to answer that question.
Okay, you've answered it. He doesn't know how to answer that question. Yes,
I was gonna say, he's already testified that he relied on the advice of counsel.
that's the answer. Next question.
Well, Judge, my last question was a little different. I was more asking him that he didn't have consent of the court. I think I know the answer, but
Well, yes, he stated he doesn't know how to answer that question.
may I rephrase? Is that okay or not? Should I just move on?
You can rephrase.
Thank you, Judge. Sir, at any point, did you have permission from the court to be in possession or to sell any guns? Yes or no?
I don't know how to answer that.
I think that was asked the exact same way, not restated, but that's okay. Go.
I'm sorry, I tried to change.
No, that's all right. Just, you may continue.
There. Sir, are there still firearms with Superman shooting sports on Leeway?
I forfeited them. I took the loss of the money and I no longer have anything.
So is it your testimony that as of today's date, you do not possess any firearms,
None.
any ammunition?
I have ammo. I did not know that was a court stipulation, but my safe is empty and it has some ammo.
Sir, why did you not pick up the firearm from Superman shooting sports when you went there with your son?
Because I'm not allowed to possess any firearms. This is exactly what Michigan State Police told me to do.
Okay. And in the video that was introduced into evidence, that was you who turned over the firearm to the police department, correct? Yes or no?
Yes,
Okay, and why did you not have your son turn over the firearm to the Southgate Police Department on that day?
because the police officers told me to put it in my trunk, drive with it carefully and bring it to the police station. My son went and picked it up from Christopher. And
Again, sir, respectfully, and I'm sorry, I don't want to cut you off, but anything you say that another person said is considered what we call hearsay, so I'd ask you to probably not to say what another person said, okay?
okay.
Thank you.
So my answer is officer, I don't believe it was Officer Kanowski. I can pull up the video from my Ring camera. Officer Kanowski was there. There was another officer. They came to my house at around noon, I want to say, or 11. And my mom called me on the phone and handed the police officer the phone. He stated that if I bring my firearm and turn it in, that they would tell the court that I am cooperating and doing everything, and they would come in here and tell the judge that I cooperate.
Again, you're talking about what somebody else told you, so that's hearsay.
Well, I was told to bring it in by an officer. That's your answer.
Thank you.
Again, that's hearsay. Counsel, next question.
Thank you, Judge. Sir, what type of firearm did you have in possession on May 7th, 2026? Was that a handgun 6-hour as well?
May 7th?
Yes, during the traffic stop in this case, what type of firearm were you in possession of? Was it a 6-hour,
Kimber.
a Kimber? And is that a
What's the
pistol?
relevance of this question?
Mr. Mohammed?
Well, Your Honor, I don't think that I'm precluded from asking this defendant.
What's the relevance to that question?
Well, I'm asking about the type of weapon. So I'm trying to see if this defendant is a collector of specifically 6-hour handguns.
Okay, but what's the relevance to this proceeding? What is the relevance?
So, Your Honor, what's been introduced into evidence under People's Exhibit number 2 and People's Exhibit number 3, it appears to be specifically People's Exhibit number 3 is a 6-hour. People's Exhibit number 1 is a document that reflects the purchase of a 6-hour. So I'm trying to determine if this individual is a collector of these types of weapons. Is this a one-off thing? Is this a weapon that he may have? The weapons that he has in Leeway that he indicated that he forfeited, are they all 6 hours? Because I guess I have this might be irrelevant, but my concern is he's making a number of purchases of firearms because what we have.
Legally.
Okay, here's what I'm going to rule. The court does not find that what gun was in Mr. Salem's possession on May 7th is relevant to these proceedings. So,
All right.
next question. The court's going to sustain the objection.
Nothing further. Thank you, Judge.
Judge, I just have a quick follow-up, if I may.
You may.
Now, every gun you ever purchased, did you purchase it legally?
Absolutely.
And in the state of Michigan, to purchase a gun, you need a permit, right?
Permit and a 7-day clearance.
And a 7-day clearance, right?
Right.
And in this case, and in this case, in every other case, you did not have any unregistered firearms, right?
Correct.
And when you appeared in front of the court, it was your understanding that you could not have any firearms in your possession, is that correct?
Right.
Okay, could you have firearms on layaway?
I'm not sure.
Okay, prosecutor referenced the gun that probably was still at the store, right?
Correct.
You indicated you put a deposit on it, right?
The 6 hour was paid off. And by when I was arrested, it just cleared at 7-day or 10, it usually takes up to 2 weeks for them to clear me.
Okay. In any event, the guns in the store aren't technically in your possession, right?
Correct.
Objection, Judge, this is leading, this is her witness. I don't believe it's appropriate for her to lead at this point, because it is her witness, but I
The
trust.
court's going to give some leeway as it's a bond violation hearing and she's on redirect, so the court will give her some leeway, but counsel, just be aware as to how you're asking the questions. First, going to overrule the objection.
Your understand, and in the order, is it fair to say that in order to get any gun that you had on layaway out of the store, you would have to have money to get it out, right?
Correct.
Okay, so is it also fair to say that your understanding of the court's order was 2 things? You can't be in possession of firearms, turn in any firearms to the authorities, correct?
Correct.
And there was only 1 gun that you did bring to the Wyandotte Police Department, correct?
It was the only one that wasn't sold.
The only one that wasn't sold, right? And your understanding of the order, was it that you couldn't sell the firearms?
And that was not stated. It was just stated that I could not possess them.
And you consulted with counsel, right?
Counsel and
And you didn't sell these firearms on the street or to your friends, did you?
my son.
Objection, what is the relevance?
I will draw.
All right, the court will sustain the objection.
So is that no further questions?
Good, I have just a couple. If I may. It'll be very brief.
Those are the famous last words of all attorneys on recross and redirect, but okay.
Thank you, Judge. Sir, you indicated that you had purchased the firearms legally, correct?
Correct.
Can you explain why 2 different weapons have 2 different license numbers, or the same exact license numbers?
Absolutely, because it took me a while to figure that out too, because I wasn't aware. Any firearms that I purchased, or let me rephrase that, any firearms that I picked up after my court date of my bond hearing, I asked the people at the counter to make me multiple copies of, so I have more than 1 copy of. The guy that I was talking to at the time made copies of, I believe it was at Supermatch. He made multiple copies of the purchase permit while it was blank.
Respectfully, sir, please, unless you know.
To
I'm
explain.
telling you.
Okay, just 1 moment. We're not having everybody all at one time. You asked him to explain. So he's explaining how 1 license number is on 2 exhibits. So please continue.
And he accidentally copied them before, so. And to make clear of that.
Excuse me,
I had-
excuse me.
Oh, sorry.
That copied before what?
Before, the transaction was, like, I wanted copies of the
Sir,
purchase.
I'm just asking before what? I'm not asking for a whole scenario.
Before the
Before
paperwork was
what?
filled out.
Okay, there we go. All right, Mr. Mohammed, you may continue.
Sir, you indicated that that individual accidentally made a copy. How do you know what he did was accidental, and how do you know what his intention was? Did you speak to him regarding the matter?
At the time,
Yes or no?
these are not yes or no questions, these are
Did you speak
explanations.
to him regarding the matter, yes or no?
No,
So how do you know that it was accidental?
because I had multiple copies of the same purchase permit, but I also had multiple copies of unused purchase permits.
So are
So when
you,
he handed me my paperwork, I just put it in the envelope. I didn't go through and how often do you get a duplicate blank? Who copies your purchase permit? Why would I use a clone purchase permit when I have multiple unused purchase permits?
Okay, all right, I think that we've gone beyond the scope of the bond violation. All right. Council, next question.
sir, have you ever used fraud or deceit in order to purchase any of the firearms?
Absolutely not.
No further questions.
Okay, I have a few questions. So, sir, how old is your son?
Ma'am, are you a whore?
He is 20.
And when did you sell the firearms?
Almost immediately after being released.
Okay, so what does that mean? Within 24 hours, within 7 days?
Within, I would say within 7 days to 2 weeks, but all the firearms.
Okay, that answers the question.
I don't know exactly, they were sold.
Okay, that answers the question. All right, so then, you went to Supermatch and CC Coins on the same day to pick up these firearms?
Yes,
When you stated that you, spoke to Michigan State Police and Southgate Police Department, did you tell any of those individuals that
Take it up with Alyssa.
you asked that you were prohibited from possessing, purchasing, or having access to guns? Yes or no?
can you repeat that near the beginning?
Did you tell anyone at the Michigan State Police or at the Southgate Police Department that you were prohibited from possessing, purchasing, or having access to guns?
With MSP?
Yes or no?
Yes to MSP. I don't know if I had that conversation with Southgate.
Hell no, she knows better.
Actually, I did. I told them that. I remember now. I told them I could not drive with it, and they told me just.
No. I didn't ask if you told them you couldn't drive with it.
Okay, I told them I could not possess it.
But which is it? You told them you couldn't drive with it, or you told them you couldn't possess it?
I told Southgate I could not drive with it, and he still insisted that I put it in my trunk and bring it up there to show cooperation.
Sir, you received a copy of this bond condition sheet, correct?
No, I did not.
You did not.
I did not.
You did not receive a copy that looks, this is a blank copy, but you didn't receive anything that looks like this.
I did not. I did not.
When bond was posted, where were you? Were you still in Wyandotte Police Department or were you at Wayne County Jail?
I think I was I had to post my bond and then they transported me to Wayne County.
Okay, so bond was posted here.
Yes,
All right, and then your paperwork goes with you there. Do you recall this court ordering you not to possess or have access to firearms or weapons? Do you remember that?
yes, Your Honor.
Do you remember the court ordering all weapons are to be turned to Wyandotte Police Department for safekeeping?
Yes, Your
So your testimony is that you did not turn in all weapons to the Wyandotte Police Department. You in fact sold some weapons after you were released.
With,
Yes or no?
yes,
Okay. And then you also, prior to your arraignment, you had 4 guns in layaway, correct?
yes,
And so then upon your release from custody,
only 2.
You still- excuse me, sir, you took possession of 2 of those and 2 remained in the possession of the stores.
I physically did not take possession.
All right, so your son took 1 to the friend. Where did the other one go? Oh, how did the other one get into your possession for you to take it to the Southgate Police Department?
So my son brought it to me. My son went and picked it up from Chris's house.
So both guns were taken to Chris's house?
No, my son bought the other one,
Which gun did your son buy?
the AR pistol,
The one from CC Coins?
yes. May I say something here now?
You may not. Do those questions elicit any further questions by the defense?
No, Your Honor.
It's her witness, that's why she goes first.
I forgot.
No, Your Honor.
Okay. By the people.
Yes. Sir, what is your son's name?
Salem. Salem,
And you indicated, did you say he was 20 years old?
yes.
And when's his birthday?
May 24th,
Are you familiar with the age associated with the purchase of the handguns?
18 and up,
How confident are you in that?
100%, look it up. They can buy them privately, they just can't buy them from the store.
And
I gave them the purchase permits for them. I have copies of my copies of those.
And the firearm that was picked up from Superman Shooting Sports, what type of firearm was that?
That was a pistol.
And
Did not buy that one.
I'm sorry,
He didn't buy that one.
did he pick it up?
Yes.
And do you know whether or not he's legally allowed to pick up a firearm being under the age limit of the purchase?
Judge, what is the relevance of this question as to whether
Hold on, sir, there's an objection, so you have to pause any answer.
he violated his bond conditions?
Well, Judge, again, if the age limit to purchase a pistol is 21,
It's not.
Sir,
Sorry.
you cannot respond right now.
Sorry.
Thank you.
if the age limit associated with the purchase of a pistol is 21, I understand there's some exceptions when an individual is 18, if it's
The
being,
prosecutor's testifying.
I'm answering the court's question.
Excuse me, I'm not having you both go back and forth. This is the response to your objection for relevancy.
So, Judge, if the age limit to purchase a pistol from a public place such as Supermatch Shooting Sports is 21, I'm starting to have concerns that his son actually picked up the firearm because if the age has to be 21 and he's 20, then I think we may need to call additional witnesses to see whether or not this firearm was actually released to his son. Because it appeared, and I'm sorry, I wasn't too familiar on the issue beforehand, it was brought to my knowledge by the OIC, but the age limit from a public store is 21 to purchase a firearm, and if his son, if he's indicating here under oath that it was his son who picked up the firearm,
Again, you
Sorry.
cannot interject.
I'm sorry.
and his age is 20, I don't know if the store actually released that firearm to his son, so that's, I guess, the basis of my question, to make a record of the situation and to,
Well, the court does find, based on that that the question is relevant, for credibility purposes, for sure. So the court's going to, overrule the objection.
sir, it is your testimony that your son picked up that firearm in that day.
He did not purchase it.
I know, you're saying that he picked it up though,
He picked it up with me.
and it's your testimony that you purchased it.
I did. And he took it to a friend's to hold until court was resolved, until Southgate Police called.
I didn't ask that. You purchased the firearm, correct?
Yes.
When did you purchase that firearm?
Now, this was.
Okay, this was before the arraignment. Next question. The court's going to sustain the objection.
Sir, what happened with that firearm after, how do you know that that firearm was transported to Christopher's home? How do you know that?
I told him to take it there
Why did you tell him to take it there?
because we couldn't possess it and he didn't want to buy it.
Who didn't want to buy it?
My son didn't want to buy that firearm.
How do you know that?
Do I have to answer this?
Sir, you took the
Just for a
stand.
moment, there's an objection.
I'm sorry, I'm really tired. But you're not. Relevance, Judge, relevance. At some point, the court just needs to decide whether or not he violated the conditions of his.
Correct.
Whether his son, how he knew where he went, where he took it. We are getting so far afield of the real question. I feel you might have to make me dinner tonight. I'm just joking.
I've already made, people breakfast and lunch today, so I'm not doing that, but the court's going to agree that there's no relevance to that question. The court's going to sustain the objection.
In your honor, I will respect the court's ruling, and if I may just slightly attempt to sway the court to reconsider.
There's nothing that's gonna make me reconsider, so next question.
Okay. Sir, did you attempt to sell the firearm to your son after the arraignment?
No, well, I don't know how to answer that properly because you're asking me a yes or no question and I don't have a yes or no answer for you.
Did you attempt to sell it to your son? Are you not able to answer a yes or no to that?
Because it's not a yes or no question, it's a yes or no answer on that side. There's more to it.
Okay, go ahead and explain.
I asked him if there's something he wanted to buy before I sold it. And he doesn't like pistols like that, so he chose not to.
Why did you ask him that?
Judge,
Okay, the court doesn't find that there's relevance to that. Is there any, you're going far afield of the question that this court, asked, and that's what your follow-up questions are to be contained within, are the question that this court asked.
Just one more question. Sir, can you identify the 4 weapons that were on layaway at the Super Match Shooting Sports? What were those 4 firearms?
I believe it was a 50 Bagel rifle. They were not all at Supermatch, by the way. It was a long rifle. I believe there was 2 long rifles. One was a sniper. One was the SIG. If I could dig through my report, I could probably find it.
I don't find that that's necessary for this court's ruling at this point.
I promise, Judge, last
We
question.
said that last time, but
No, I apologize. Sir, how many SIGs did you possess at one time?
Judge,
and you need to clarify which time frame you're speaking of, counsel.
Since the arraignment?
One. That one.
Understood. Nothing further. Thank you.
maybe step,
Anything else, counsel?
no, maybe.
Yes, you may sit down. Any further witnesses for the defense?
No,
All right, any further witnesses for the people?
No, thank you, Judge.
All right. Okay. Arguments by the people.
Your Honor, the testimony in this case, I believe, supports that a bond violation had occurred. I'll leave it to Your Honor's discretion to make that determination, but I think there's sufficient testimony. I will say that it is based on my assessment that there were certain moments during the defendant's testimony that suggest that he wasn't credible. However, I will again defer to the court's discretion and assessment as that I've seen a number of witnesses provide testimony, so I think the record speaks for itself and I'll defer to the court's discretion.
Great, and Ms. Longstreet?
Judge, I will defer to your discretion. Also, just give me a little latitude. I didn't know much about this case before I got here today. Quite frankly, I've been managing the record at VS for about 3 years, so I don't have cases. But I was a public defender for 17 years. And when I met Mr. Salam, and he told me the ATF was here asking about his purchase of weapons, I found it, I'm going for it. It's gonna go to the bond, right? Because one of the things that we do in reference to setting bond, right, is you want Mr. Salam to abide by the court order, but there's a purpose to it, right? Because I get this case involved a firearm, right? And I'm looking at the file and I see originally CCW, felony firearm, and a possession charge, right? And then I discovered that he doesn't have a prior. So that's not an issue, because normally you see the felony firearms tied to some prior felony offense. That's not the case. The gun he had, legal gun, registered. It wasn't a street gun, which in my 17 years, I promise you, I've seen a lot of street guns, right? I've never seen or met a client who is so knowledgeable about the purchase of guns, whether we think he should have them, whether we think he should be purchasing so many guns, whether we think based on maybe where he's from, whether or not he should be given a permit to have guns. Because this doesn't happen all the time. And so the only thing I want to say to the court is, welcome back to really arguing on behalf of a client here. And I know the court respect of the court's orders. If we don't have that, we don't have anything. But I will ask the court to look at everything Mr. Salam has done. Every purchase of a gun was legal. He had a valid permit. When the court told him, you can't have possession of a weapon, turn it into the police, he did that. He didn't try to run, he didn't try to take it to someone else's house, and it was registered and legal. And so I understand that the court is looking at this and thinking, this is a close call. I told him he's not supposed to have any weapons, right? So he gets out of jail. He has these weapons that he's begun the purchase of, right? He doesn't want to lose his money, which is sort of like a fact of life for people who find themselves in the system after he's already been locked up, 6 kids, wife, paid the bond, is trying to make up for something he did wrong. And the reason why I am advocating so strongly in this case, because this is a man they offered a misdemeanor to this morning, right? And so, and he struggled with it because he's like, I get out here. But the system is beating him up because now we're spending 2 months on a bond hearing for someone that they just offered to a misdemeanor. And I don't know, the court may not take that into consideration in the calculation, but I hope the court sees more than someone who violated a bond condition in a case where he was just offered probation and a misdemeanor. Thank you, Judge.
All right, thank you.
Your Honor, may I briefly respond to that?
Okay,
With all due respect, I don't believe that my office extending a resolution in this case should be used as weight to deny a bond violation. One thing I've learned during my few years as an attorney is that the court speaks through its orders. And Your Honor, you spoke through your order when you ordered the defendant not to possess any firearms, and if he does possess firearms, to turn it over to the police department for safekeeping. We need to respect the order of the court, and we have to respect the judge and her requests and order. And in this case, you ordered the defendant not to possess any firearms. You also ordered him to turn over the guns to the police department. To me, based off of the testimony, it shows that the defendant did not comply with that order. I will leave that for you to decide, Your Honor. I've asked to just, the testimony speak for itself, but this isn't a situation where we're attempting to punish the defendant or anything. This is the law, and we have to follow the law, and we have to follow the court's orders. And so I'll reserve any further argument, but I just wanted to highlight that for the court. Thank you.
okay, thank you. All right, the court heard testimony as well as reviewed the stipulated exhibits and the video. It is clear that this court's order was for Mr. Salem to not possess or have access to any firearms and or any weapons. And all weapons were to be turned over to Wyandotte Police Department for safekeeping. Now, the court, will give some, consideration to Mr. Salem not having a copy of this somehow. The Wayne County Jail didn't provide that to him, which is a problem. And that's only in regards to purchasing a firearm. Because on item 11 on the back page of the bond conditions, it reiterates not possess or purchase a firearm or other dangerous weapon. So that just sort of clarifies what this court had previously put in here on page 10. So what this court's focus is on is the disregard for this court's order. First, this court ordered all weapons to Wyandotte PD for safekeeping. If there is a request to sell those items, those firearms, there should have been a motion appropriately filed before the court. The court will also will note that there is some credibility concerns with Mr. Salem as it relates to his testimony that his son was in possession of the guns, because now it's a concern as to whether or not his son legally had the ability to have the guns, and whether or not or Mr. Salem was a front for the purchaser, but then to provide those with his out-of-time responser to provide it to his son. The court will also note that the testimony was that Mr. Salem had multiple purchase permits. Further, that there were multiple guns in layaway. And I believe the testimony was that he received refunds on some of those, refunds of the deposits on some of those that were still at the store, and others that he lost his deposits on and no longer purchased the guns. The concern that this court also has is that Mr. Salem seems to have contacted his prior attorney, Michigan State Police, as well as Southgate Police Department, all of which were not Wyandotte Police Department, which is where this court ordered the weapons were to be turned for safekeeping. Further, if there is an issue regarding the guns that were in layaway, that could have been addressed at the arraignment. And there could have been more clarification. And that, I don't believe that was brought to the attention of the court at all. But given the nature of the charges in this matter that the court had at the time, that, and this is what this court's basing the bond violation hearing on, because that's where the court set these conditions for bond. What's happened since then, whether there's been charges dismissed, offers made, is not relevant for this court's ruling today. So the court is going to find Mr. Salem guilty for violating this court's bond conditions. And the court's going to,
Well, hallelujah.
court's going to order 7 days jail.
All right, I'll take that.
For violation of this court's order.
Go sit in the can.
I will give you a date to, yeah,
Ask about that. I thought you were
I will give you a date for it in the court. July 27th.
I wanted to hang an instant, but I'll take it.
Yes.
Your Honor, if I may, I don't know if you're referring to me or defense.
No, Ms. Longstreet wanted to address the exam.
I want. At least schedule a thing for it. I have to take out,
We can't do it today.
it's fine. Judge, I respectfully asking for another date for the exam. I will tell the court that, you know, this is bond hearing, a lot of information I didn't have the benefit of, and my understanding is with the other case, Mr. Salem may have filed a motion, he has some other things, and I want his grievances to be heard and I want him to have a full and fair opportunity before the court. So I'm asking for a exam date.
Okay, your response, Mr. Mohammed.
I guess I'm not fully comprehending what defense counsel is asking.
She's asking to adjourn the exam so that she can go over newly discovered information that she did not have access to or privy to prior to the bond violation hearing today. Is that accurate, counsel?
That is.
Okay, that's what she's asking.
Judge, I'll defer to the court's discretion, but I will not agree to it. But what I will say, Judge, and I do need to make a very clear record, is this is a request, as your honor is aware, just for the record, this is a request coming from the defense. We are prepared again. This is the third preliminary examination where the prosecution has had all witnesses present. We've been prepared to move forward with the exam every single time. However, we will defer to your honor's discretion. There is one additional thing I'd like to address regarding bond, but I'll wait for the court's decision as to the defense's request to adjourn again.
Judge, do you want me to respond?
So just for clarity, we are ready to go today.
I understand. But I also understand too that that given the issues that are occurring at the Neighborhood Defender Services as well, that and given the newly discovered evidence that it appears both sides have learned today that it's not an unreasonable request. I'm also very keenly aware that officers have once again been present all day, prepared for this exam. The court's also keenly aware that it's 5 o'clock and that the delay this time isn't necessarily the court. It was issues with defense counsel, not specifically Ms. Longstreet, but Neighborhood Defender Services in general, not having apparently the appropriate information to have appeared. And then it wasn't, we didn't even begin things until after 1 o'clock. This was originally scheduled to begin at 11:30. And given how the bond violation, the tenor of the bond violation, the court has to take into consideration the timing for all involved, including the court staff. So I am going to grant defense request for an adjournment. If there's I will say that the motion that's currently filed is not something this court's going to accept. And so just so there's not any misunderstandings and we can be clear, the motion that was filed on July 22nd, this court already ruled was not properly filed because it was not timely. So that motion is not going to be moved forward on. Now, if either side's filing motions post today's date, that's something different. But the July 22nd motion that was filed is not proceeding because it was not timely filed. Nor was there a request made for the court to determine if there was good cause to waive the requirements under 2.119.
Understood, Your Honor.
Okay,
I'm just gonna look at my calendar on my phone.
okay.
Court's not give us a date.
Well, I am. But we're looking at least now there's only a couple witnesses you have to coordinate with counsel and not 7 or whatever the number was before.
Sure.
We're looking at August 27th or August 27th.
Which I would have no objection to Thursday, August 27th.
Yes.
What time?
Well, I'd like to say 10 a.m., but I don't know, Alicia.
Thursday?
It's a Thursday. Does that work for your witnesses, Mr. Mohammed?
I can go check, there's fully sitting in the car.
Okay.
Just want the, while we're waiting, is it that you want Mr. Salem to turn himself into the court or the jail on Monday?
He will,
You know where the other house is?
he will have to,
So Judge,
help to communicate with probation to get that information, as to the procedure, but it will be at the jail.
Judge Officer Harris, will not be available that day. It's my understanding that he's anticipating the birth of his child on August 29th.
That's completely unacceptable. How do you know she's gonna go early? I'm kidding. I'm kidding. Okay. Ms. Munster, did you spell your first name with a K or a C?
Okay.
Okay. Kristine?
Yes.
Okay. Okay. How much time off?
I will be off till October 1st.
Of course you will be. As you should be, to be quite frank. Okay, we can't go that far out. Well, there's, the other option is, are you off that whole week before the birth?
The birth is this Thursday or Wednesday.
Oh, you meant the 29th of July.
Correct.
Oh, and you're off until October? Good for you. Wow. That's fantastic, actually.
I guess, Judge, my concern with an adjournment at this point would be some sort of speedy right violation. That's why I'm hesitant to now agree to an adjournment, considering
There's no trickery over here, Mr. Mohammed. Mr.
if the defendant is stipulating to this future date and any potential type of
Hold on, you know what? Something occurred to me a short time ago. I'm gonna see counsel and chambers. Let's go off the record.
All right.
All right, so we are back on the record in the matter of the state of Michigan versus Mohammed Salem, 26586, in appearance for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Oh, it's about good evening at this point, but yes, okay.
Christine Longstreet of Mr. Salem.
Mohammed said,
Very good, thank you. All right, so the court did have significant discussions in chambers regarding some of the challenges that it's had to, that we've had to navigate in relation to scheduling an adjourned date. So it's been agreed upon that it's going to be Tuesday, July 28th at 10 o'clock in the morning. And the court's going to, sir, amend your report date to the Tuesday later in the afternoon or evening or whatever that may be. So you don't have to go on Monday. We're going to contact the court, or we're going to contact the jail, amend the paperwork that was set down to that end. Okay?
Okay. Be here to the clock sharp Tuesday.
Yes, bonding conditions are continued.
Judge, if I may, there's just a couple things. My apologies.
Okay,
Thank you. Your Honor, considering the history and but as far as the preliminary examinations, at this time, I'd like to place on the record and invoke the prosecution's right to a speedy trial. At this time, we're not claiming there's been any violations. However, to ensure moving forward, the case continued to proceed as it should, we're just invoking that right. It is our constitutional right as well. As well as I'd like to also state on the record that our position as the bond, if I may address that as well.
All right, just a moment. The court is going to indicate that it's this court's intention that this matter move forward. The court has also stated on a number of occasions regarding the procedural history of this matter that there have been various reasons why the exam has not proceeded on the scheduled date. The court will also note that it is taking into account and into consideration both the prosecution's right and the defense right to a speedy trial. And that is why we are pushing this for Tuesday. Hopefully, the baby doesn't want to come out before that. So,
And I want to thank you, Your Honor, for accommodating all parties in this case throughout the entirety. The court has done amazing in that aspect. I did want to address bond, specifically the GPS tether. So it's my at the last hearing, we did defer to the court's discretion. However, considering in light of the case or the new bond violation, we are requesting that the defendant have a GPS tether imposed. Our concern is, one, that he could potentially flee the state. Additionally, as the record reflected and the violation reflected, he had disregarded.
please be careful because that's going right into my court reporter's ears.
The defendant had previously disregarded the orders of the court. And so we do believe that, one, he poses a potential flight risk considering his prior, what the testimony reflected in the bond violation, that he's disregarded the orders of the court. So there's a concern for that. Additionally, there's a concern considering the fact that a purchase license number was used multiple times. I understand the defendant had testified that it was due to another person making a copy, but we don't know that for certain. There's been no testimony by that other person. My concern is he's going to other states, potentially purchasing firearms, potentially selling firearms. We don't know. So to address that concern, I think a GPS tether, which requires him to be here in the state, should be imposed. It will monitor the defendant's location, as well as it will ensure that he will not be a flight risk and disregard the court's order to remain in the state of Michigan, as well as now the court has sentenced the defendant to 7 days in jail. And so to ensure all of this, I'd request that the bond reflect a GPS tether considering the totality of the circumstances, both the disregard of the court's order, the testimony in this case, and the violation the court had found. Thank you.
Okay. Before I give you an opportunity to respond, counsel, Mr. Mohammed, is there any information that you have that this court hasn't heard already that would give support to your concerns or fears that Mr. Salem is going to leave the state?
So, Judge, my concerns are based.
No, that was not my question.
There's been no additional information outside what the record reflected through the bond violation and the arguments that I've put forth. My request is based off of, one, the court's now found the defendant to disregard the order of the court. Additionally, there's been testimony taken by the defendant where he doesn't appear to be a credible person. Additionally, the court has now sentenced the defendant to 7 days of jail. Considering all of that in its light, I think that a GPS tether to ensure that the defendant is appearing for the court hearings as well as his jail sentence, that's what the GPS is going to do. It's going to ensure his presence. There's a license number that was used.
Right, but counsel, how is the GPS tether going to prevent that? Because if I recall correctly, he was on a GPS tether when he was in the store, right?
Yeah.
Yes, Judge. But what it does is it goes to
It has some.
I'm sorry,
Go ahead.
Judge. I'm relying again based off of the testimony and what the court has found. In light of that, that's why I'm making my request.
Judge, I'm gonna make a record. I'm trying not to be offended for Mr. Salem, but if anything, he's here before the prosecutor. He's sending you motions. This idea that somehow he wouldn't appear in court, he's representing himself. He turned the gun in. The guns he's purchased, he's all done it legally. I don't know where we made this left into making the fact that he may have violated a bond condition, right? Not that he fled, not that he wasn't at court on time, not that he went somewhere out of his state. And all these suggestions, if you got charges, bring them. I heard that.
Counsel, address the court, not Mr. Mohammed.
Okay, I heard that the ATF was here to talk to him. If they have charges, they should bring him. He doesn't need a GPS tether. The court has given him 7 days for the violation. He's here now. He's been here. He was here before me. And he was emailing, filing his own motions. That's not an issue. And as the court pointed out, he had a GPS tether when he apparently went into the gunshot. I'll stop.
Judge, if I may, well, if we're focusing purely on the history, we have to also acknowledge there was a previous hearing where the defendant failed to appear, right? I'm not relying on that solely. I'm actually giving that the least amount of weight in this argument, because at that time I had not even motioned for a capias, because I looked at the totality of the situation we had before us. He had appeared in court on that day, not before the actual court, but he had submitted motions. So I didn't think his intention at that time was to evade. It's normal, typical behavior to for a prosecutor or the court to issue a bench warrant when an individual fails to appear. But what we did, Judge, on that day is we assessed the situation and we made a decision based off of
Don't worry, there's only 3 more hours.
what we believed at that time. However,
Who's we?
well, Judge, I didn't motion for a capias and Your Honor didn't issue a bench warrant on that day.
Right, but I will state for the record that you and I were not discussing collectively
So this was
and made a decision as to what direction to go to. So I just wanted to clarify that for the record, that
Yeah.
if you're saying we, that's not you and I, you and the court together are making that decision. I just want that to be clear for the record.
Absolutely, Judge. Everything was on the record, but I recall speaking on the record and saying that it wasn't based off of my assessment of the situation. It wasn't the defendant's intention at that time to evade the court. So based on that, I did not motion for a capias.
Right.
And the court seemed to agree with that assessment, which is why the court didn't. And I apologize for speculating on the court's behalf, but that's just what I gathered based at that time. What I'm trying to say, Judge, is we take every case by way of saying the prosecution, case by case, based on the facts at that time. And as of this moment, there has been a change in circumstances. That change is what the testimony reflected. The defendant had acknowledged being in possession of a firearm without a CPL. That was reflected on the record. What's also changed, the court has now found the defendant in violation of the court's order. The defendant had disregarded an order of the court. That is a fact. And so when there is now a history of, now I am giving that previous failure to appear a little more weight than I did at that time. Now, I'm not relying on that solely, but it's a factor to consider along with everything in its totality. And so now that the defendant is facing 7 days jail, there's been a clear disregard of the court's order and all the factors I've already mentioned. Based on that, I think there should be a GPS tether imposed. I'm not saying that we should now change this to a cash bond and he should, his bond should be revoked permanently pending this case. All I'm saying is this change in circumstances, based on my assessment, warrants a monitoring of the defendant's location. I'll defer to the court's discretion, but that is just the position of my office at this time, considering the new information. Thank you.
Okay. And it is the position of this court that I do not find that there has been a sufficient change in circumstance to warrant Mr. Salem having a GPS tether put on at this time. The court will note that they did grant the request on July 16th to remove the tether. that, at that point, at that time, Mr. Salem was still, pending the bond violation as well. The court will also note that Mr. Salem has his, usually it's his wife, his spouse, and 6 children, locally here as well. And that there is not any prior failure to appear history, even when he had matters in the circuit court that he had, to appear on in jury trial or something of that nature. I don't show anything in his criminal history of any failure to appear history. So bond and current conditions are continued.
Thank you, Judge.
Thank you. Have a good day.
Thank you.
Off the record.
Ah, there you have it. There you have it. I wanted to hear some more from Muhammad. He's got a whole new fan base after today. Let me see.
You know what? I sure love those muffin tops.